morning.
Good morning, my lords. I was dealing yesterday with issue 1, namely, is there any binding authority in Meta's favour? And I had completed my submissions about the Vass case. I was going to turn next to the Devonish case. And if I can reiterate, as it were...
Can we just in relation to authorities, we feel we do know them pretty well.
Yes.
And I don't think we need to be taken at great length to them. What we're really interested in is your submissions on the authorities. And I hope that enables you to take it more shortly. But not only have we had extensive submissions from Mr. Mitru on them, we've read them independently, we've discussed them.
Right.
So we'd really like your submissions. And of course, if you wish to refer to particular paragraphs,
yes,
do so.
Yes.
But I hope that's helpful.
I'm very grateful for that indication, my lord, and I'll take it as quickly as I can. Just to give your lordships our two headline points on Devonish. First, we submit that Devonish does not say that user damages are unavailable for non-proprietary torts. What Devonish says is that restitutionary remedies, such as an account of profits, are unavailable for non-proprietary torts. Second, if contrary to our first point, Devonish does say that user damages are unavailable for non-proprietary torts, if it does say that, then that is, with respect, no longer good law. So those are our two headline points. And I wanted to begin my submissions on Devonish by identifying, although I suspect your lordships have this, and I won't go to the passages unless the court would like me to, but it's important to identify what was actually in issue by the time the case came to
I'm sorry, just one moment. Is there anyone from Opus here? My system doesn't seem to be working. It's not started.
Mine's the same.
I think it's the same for Lord Justice Phillips. Is yours up? No, it doesn't work for any of us. Work for you? No, it doesn't work for anyone. Right. Now anyone can say whatever you like and it won't be recorded. Says it up there, live streaming. I withdraw that comment. I wonder if we ought to just rise for 5 minutes and let this be sorted out.
Absolutely.
Everyone's got and he actually came in the first yesterday and I always thought about it. It's so hard to go through before it's like all the way around there. Exactly it. Yeah.
Which one's that?
I actually did need to do it today. Nanny was here all day. List. Going on holiday. Anything. No, I was about to say that. Just use everything. Great. And then maybe I'm going to take the job. So today they went, they're not there, but yesterday they were like, oh yeah.
Okay.
That's an
I will take it out.
Hi.
Where are we on the list? Thank you.
It's
Do you
like-
need any help?
Is your power working?
No, she just asked before. I don't think it is ready. You're not allowed to talk to her. Do you have power?
No.
Yeah, do you want this one? Yeah, let me do it. No. You have to be a bodybuilder.
Oh my god, you're gonna pass that. Oh, because you haven't.
We think we should just get started. There'll be a transcript in
Yes,
due course.
Indeed. I'm grateful. I had made the two headline points that we have about Devonish, and I was going to begin my submissions on Devonish by identifying what was actually an issue by the time the case gets to this court. Because by the time the case gets to this court, Devonish had abandoned its claim for exemplary damages, which was one of the remedies it had sought at first instance before Mr. Justice Lewison. In this court, the only remedy that Devonish was seeking was an account of the illegitimate profits made by the cartel, and it described that remedy, an account of profits, as quote-unquote a restitutionary award. In the light of my Lord's indication, I won't take the court to it, but there are 3 passages which contain a helpful explanation of what was an issue, and one of those passages has a worked example showing numerically what was being claimed, and those are para 140 and 141 in the judgment of Lord Justice Longmore. That's Authorities, Volume 1, Tab 8, page 194. And the worked example showing what Devonish was seeking is at para 151 in the judgment of Lord Justice Stuckey at page 198. But the simple point is...
Were they seeking, in the Court of Appeal, was it as an alternative to compensatory damages or over and above the overcharge compensatory damages?
As an alternative, but that's subject to this important qualification. What came to the Court of Appeal was Mr. Justice Lewison's determination of a preliminary issue.
Yes.
And the preliminary issue was, can you get, instead of compensatory damages, in part because they were saying it's inadequate, can you get exemplary damages or an account of profits? So what they were effectively seeking in this court is an account of profits in the event they couldn't prove any compensatory loss. And the concern, this is actually identified by Lord Justice Longmore at para 140. The reason why they were doing it is they were concerned that if they were to seek compensatory damages, the claim would fail because they had passed on their loss to downstream customers. That was the concern. But what they were not seeking in this court is user damages. That's actually common ground. It's accepted by my learned friends at para 23 of their skeleton argument. Indeed, not only did Devonish not seek user damages, Devonish could not have sought user damages because Devonish is a cartel case, and there was no suggestion that the cartel had wrongfully used any property or identifiable assets of the victims. What the cartel had done was to cause loss to the claimants, generating substantial profits for the cartel, but they did not prevent the claimant from exercising a right to control the use of any assets. It's a very simple point. Now, in this court, the linchpin of Devonish's argument for an account of profits was the speech of Lord Nichols in Attorney General in Blake, which we looked at yesterday. Because, of course, in Blake, which was at the time a path-breaking decision, the House of Lords had said you can, albeit only in exceptional circumstances, get an account of profits for breach of contract. It was almost the one step in Morris Garner of the day, if I can put it like that. But the difficulty that stood in Devonish's way was, of course, that Blake was a contract case, and Devonish were advancing a tort claim in this court. And they sought to overcome that difficulty by contending, in essence, that if an account of profits is available in exceptional circumstances for breach of contract, it should, in similarly exceptional circumstances, be available in tort. That was the argument, coherence in the law of remedies. Now, as your lordships know, that argument was rejected by this court, but only because Lady Justice Arden considered herself bound to reject it by the judgment of Lord Justice North in Vass. And I say only because, I use that phrase because if one looks at Lady Justice Arden's reasoning, she was actually attracted by the argument that Blake represents a new start, that there should be coherence in the law of remedies. And it would appear from some passages, which I'll take the court to if that would assist, that if Lady Justice Arden had considered herself free to form an independent view, she would have held that in exceptional circumstances in the law of tort, including in competition cases, you can get an account of profits. It may not have worked on the facts of Devonish, but as a proposition of law, she was inclined to accept it, but she didn't. Now, what my learned friends principally rely on is para 76, which your lordships have looked at more than once, where Lady Justice Arden said that she is bound by Lord Justice North in Vass. And then she says, perhaps we just should turn this paragraph up since it's central to my learned friend's argument. Page 178, volume 1, tab 8, page 178. Just below line B, there's a sentence starting with, nonetheless, it was an essential part of North LJ's reasoning that damages by reference to the benefit obtained by the defendant could only be awarded in those limited situations, and it would have to be shown that his circumscription of the cases where damages were not assessed on a purely compensatory basis could not stand with Blake's case. 2 points on that. First, it's significant that Lady Justice Arden in that sentence, which is really the linchpin of my learned friend's argument, refers only to the judgment of Lord Justice Norse in Vass and not to that of Lord Justice Nichols. So she considers herself bound by Lord Justice Norse's judgment to say what she does here. But the second and more important point is, all that she is saying in our submission is that you cannot get restitutionary remedies in the law of tort, hence the use of the word benefit just below line B, save for proprietary tort, so save in the situations identified by Lord Justice Norse. It's not saying anything one way or the other about whether you can get user damages, and that's not surprising because user damages were not an issue before this court. Now, that interpretation of Devonish, of para 76 of Devonish, is consistent with the views of Lord Burrows, or Professor Burrows, as he then was. And can I quickly show your lordships that? It's Authorities, Volume 5, tab 57, page 2221. Tab 57, page 2221. And if we could go, please, to page 2233. 2233. About halfway down the page, there is a subsection 5, which is titled Devonish. And then in the final paragraph on the page, Professor Burrows says, it was held by a majority of the Court of Appeal, Arden and Tucky LJJ, that a restitutionary award could not be made for the tort of breach of statutory duty in issue in this case because it was not a proprietary tort. Vass was held to be binding authority for refusing restitution. Again, I'd emphasize that word, restitution, except for proprietary torts, and that case was thought not to have been overruled by the wider reasoning of the House of Lords in Blake. Even if incorrect on that, a restitutionary award could only be made if there were exceptional circumstances of the kind described in Blake, and here that was not so because compensatory damages were an adequate remedy. And then over the page, Professor Burrows says that while he agreeing with the result because he did not think there was any good reason on these facts to extend the law of restitution, you get that once again, for torts, especially where the claimant had passed on its laws, Lord Justice Longmore disagreed with the majority that Vass stood as a blocking authority. I do not consider that Vass is authority for the proposition that the categories of cause of action in which it is permissible to order an account of profits are necessarily confined to tortious claims for breach of a proprietary right. Lord Justice Longmore should be supported on this. With respect, the majority's approach to the Vass case is flawed because in particular Vass concerned a proprietary tort, the tort of private nuisance, which is the point I was making yesterday by reference to the incorporeal hereditament. Therefore, the restriction on restitution in that case cannot have had anything to do with restitution being limited to proprietary torts. It's also arguable that the reasoning in Blake has moved the law of restitution on beyond the restriction to proprietary rights. So the simple point we make is that on a proper interpretation of Lady Justice Arden's judgment as a whole, one mustn't pick out individual phrases, but reading it as a whole, all that Lady Justice Arden is saying is she considered herself bound by the Vass case to hold that you can't get an account of profits or other restitutionary remedies in the law of tort, save in the instances identified by Lord Justice Norse. She isn't saying when you can or can't get user damages. So that's really all I wanted to say about our first headline point, which concerns the proper construction or interpretation of Lady Justice Arden's judgment. But my second point really takes my learned friend's case at its highest. Let's assume your lordships reject my first submission and you were to hold that Lady Justice Arden held, it would have to be by implication, in para 76, that Vass is authority for the proposition that you can't get user damages for non-proprietary torts. The question then is whether that implicit conclusion is binding. We respectfully submit it's not. in our skeleton argument at paras 50 to 57, we've identified 6 reasons for that. In the interest of time, I wasn't going to deal with all of those, but can I just pick up a few of those points? Why we say, if Devonish means what my learned friend says it means, it's no longer good law, or it's no longer binding. Our first point, my lords, is a very simple point. It is common ground that user damages were not claimed in Devonish. That's, as I say, common ground. And in the one-step case, the Supreme Court explained that if user damages haven't been claimed in a particular case, then that case can't be binding authority about the availability of user damages, because the case is only authority for what it actually decides. That is at volume, again, I ought very quickly to show your lordships this, because I'm not sure we have looked at it before. It's
This is just the point about binding authority.
Yes, and Lord Reed
Particularly
refers
the
to
quotation for it's limited to the facts of the case. We've seen that in, is it one step? I think it's been quoted.
It's exactly that. Your lordship has the point. It's para 82. I don't think I need to go.
One step, para 82.
That's page 298. And Lord Reed refers to Quinn and Leatham, which says that, quote unquote, a case is only an authority for what it actually decides. It's
That little pithy aphorism which is set out there.
Indeed. So that's my first point. I don't think I need to say anything more than that. Indeed, one point I ought to make is yesterday I showed your lordships para 65 to 66 of one step, where the Supreme Court disagreed with Lord Nichols and Blake. And the Supreme Court said Lord Nichols was wrong to have adopted a restitutionary analysis. But what is very interesting about those passages is that the Supreme Court was able to disagree with Blake without having to invoke the 1966 practice statement. Because, of course, when the Supreme Court or the House of Lords is departing from prior otherwise binding authority, they have to invoke the 1966 practice statement. They normally sit in a constitution of 7. So one has to ask oneself, how was the Supreme Court able to disagree with the House of Lords without invoking the practice statement? The answer is, because user damages weren't claimed in Blake, it's not binding authority, what Lord Nichols said about the legal characterization of user damages. But we say the same reasoning applies to Devonish. So that's really that point. My second point is this. There is a principle in the law relating to the doctrine of precedent that a court can only be bound by a prior judgment if that judgment contains a clear ratio. The ratio has to be clear. And that is, that principle, the authority for that is the activist case, which I'm not sure we have looked at. That's Authorities, Volume 2, tab 29. Page 767. Now, again, this case, my lords, concerned an application by activists to revoke a patent which had been obtained by Merck. The detail of it doesn't matter for our purposes. But what had happened was that at first instance, Mr. Justice Warren considered himself bound by a Court of Appeal decision called Bristol Myers and Squibb to uphold the revocation application. And one of the issues in this court was whether this court was bound by Bristol Myers because it was a Court of Appeal decision. Now, if we could go please to para 56 at page 784 in the judgment of Lord Justice Jacob. At line E, Lord Justice Jacob says it's only a decided point of law ratio which matters for the purposes of precedent. And then he says this, as will be seen below, it is only if there's a clear ratio of a first Court of Appeal that a subsequent Court of Appeal is bound by it. And he identifies a rationale for that. But I should just say, we don't need to read it, but from para 57 onwards, there's a lengthy analysis of Bristol Myers and Squibb, in which, as in Devonish, there were multiple judgments which did not speak with one voice. And then at page 789, there is a heading just above line F, which says, what if there is no or only an obscure ratio? So that's where he deals with the law relating to what you do if it is said that there is a ratio, but it's not clear. And at para 80, he says, as for an individual judgment, although we suppose every judge who writes his or her own decision tries to articulate a ratio, it would be an article of faith and contrary to reality to say that every judge has succeeded or that a ratio can readily be distilled from every judgment. Then he poses the question, how should the doctrine of precedent apply if there is no clear ratio to be followed? Michael Dunedin said in Great Western Railway and Owners of Moston over the page, it's a House of Lords case, when any tribunal is bound by the judgment of another court, either superior or coordinate, it is of course bound by the judgment itself. And if from the opinions delivered it is clear, as is the case in most instances, what the ratio which led to the judgment, then that ratio is binding. This is then the sentence we rely on. But if it is not clear, then I do not think it is part of the tribunal's duty to spell out with great difficulty a ratio in order to be bound by it. And then, I mean, one might say, what is the rationale for this? If there's a ratio, there's a ratio, even if you have to work hard to find out what it is. But he answers that question at para 83, at page 790. Lord Justice Jacob says, these statements of principle are evident common sense. The purpose of the rules about precedent is to produce certainty. If a particular precedent is itself obscure, trying to follow it is likely to perpetuate uncertainty rather than achieve it. Since we are satisfied there is no clear ratio of the Bristol-Myers Squibb case, we are free therefore to hold and do hold that we should follow the other case and allow the appeal. So that's the principle in activists. Now in our case, taking my learned friend's case at its highest, the ratio of Devonish for which she contends does not, in our respectful submission, leap off the page as it were, but can only be spelt out with some difficulty, requiring a close analysis of individual phrases used by Lady Justice Arden and of possible assumptions underlying those phrases. For instance, what did Lady Justice Arden mean by the phrase, damages by reference to the benefit obtained by the defendant? Does that by implication extend to user damages? But if that's the length to which the court needs to go to find a ratio, then that itself shows, applying the principle we've just looked at, that the court isn't bound by that ratio if it can be extracted from Devonish. So that is our second point about why Devonish is not binding. Our third point, which I briefly foreshadowed yesterday, is this. Yesterday, at transcript day 1, page 63, lines 1 to 5, and page 73, lines 12 to 18, my learned friend accepted in response to a question from my Lord Justice Zacaroli that the Court of Appeal in Devonish did proceed on the basis that user damages are restitutionary in nature rather than compensatory. And my learned friend, with respect, was right to accept that. But your lordships will recall that what my learned friend then suggested was that this flawed premise only affected what my learned friend described as stage 2 of the Court of Appeal's reasoning and not stage 1. So she has the stage 1, stage 2 point. She says there are 2 stages. The flawed premise only affects stage 2, but I only need stage 1, which therefore remains binding. Now the 2 stages are set out in my learned friend's skeleton argument, which may be worth quickly turning up. It's para 28.
Just when you say that Devonish proceeded on the basis that user damages were restitutionary,
Yes.
I have to check. Devonish didn't use the phrase user damages, did it? So how could it proceed on the basis it was it proceeded on the basis that an account of profits was restitutionary?
We respectfully agree, my lord. That's why we say the argument fails at a prior stage in the analysis. But I'm now working on the assumption I'm wrong about that. That right. Even though
so, if Devonish was concerned with user damages, it treated them as restitutionary.
Yes. And it would have had to, because if one looks at the phrases used in para 76, on which my learned friend relies, it says things like damages which are measured by reference to the defendant's benefit, damages which are not purely compensatory. So the only way my learned friend can put user damages in that paragraph is by saying, Lady Justice Arden considered that restitutionary remedies or benefit-based remedies extend to user damages. Now, I
understand Meta's case to be that Devonish was concerned with an application for an account of profits, which were treated as restitutionary. I don't think it said that the judgment was specifically about user damages.
No, I think what is said, maybe we should look at para 76 again of Devonish. What is said, as I understand my learned friend's case,
Certainly, it wasn't part of Mr. Justice Lewison's analysis at first instance.
No.
That was simply an account of profits. It's restitutionary. Is it available?
indeed so. If one looks at para 70, first of all, if we just look at 74 at page 177, the ratio of VAS is stated by Lady Justice Arden in narrow terms which do not assist my learned friends. It says the ratio of the judgment of Lord Justice North is that the user principle ought not to be applied to the infringement of the right to hold a market. So that of itself doesn't help my learned friends, which is why they need to go to 76. And in 76, at page 178, they rely on the in particular, they rely on the sentence just below letter B, which says, nonetheless, it was an essential part of Lord Justice North's reasoning that damages by reference to the benefit obtained by the defendant. Now, we respectfully agree with what my Lord Justice Green put to me, which is this is not saying anything about user damages. But I'm assuming now
I treated that as a shorthand for an account of profits.
Yes, or other restitution, but probably just an account of profits, because that is all that was an issue in Devonish. Nothing else was being claimed in this court, other than an account of profits. But if I'm wrong about that, if somehow this sentence has to be read as meaning that it also includes user damages because of the cross-reference to the VAS case, which is how I understand the argument to be put, it can only extend to user damages on the basis that Lady Justice Arden regarded user damages also as restitutionary, and indeed regarded Lord Justice North and VAS as having treated user damages as restitutionary. So you need all those additional steps before you get to the ratio for which my learned friend contends. But the submission I'm making now is if you undertake those additional steps in the analysis and you get to where my learned friend wants to go, the argument still doesn't work, because at that point in the analysis, what is put forward as the ratio of Devonish is founded upon a premise which the Supreme Court has subsequently rejected.
Which is that it's restitutionary, not compensatory.
Compensatory, not restitutionary.
The Supreme Court held it was compensatory.
Yes, exactly.
The Court of
yes.
Appeal error.
Precisely that. Precisely.
Yes.
That. And what I was dealing with was what I understood.
Sorry, just to be clear, it treated whatever it was that was being claimed for as a benefit to the defendant as restitutionary, not compensatory, and in one stop they held it was compensatory.
Exactly. Exactly. And what I was dealing with was, yes.
What's happening is there's a bit of a jigsaw going on, isn't there? That pieces are being fitted together.
Sorry, my lord, I didn't.
There's a bit of a jigsaw process because there's no doubt that WAS was dealing with user damages.
Yes.
And the conclusion, what Lady Justice Arden says is that it was an essential part of Lord Justice North's reasoning that damages by reference to the benefit obtained by the defendant could only be awarded in those limited situations. And that was the case unless Blake said otherwise. But then the last part of that paragraph,
yes,
it cannot be said that a case that hold that damages assessed on a purely compensatory basis are the only damages available for the torts other than proprietary torts,
yes,
is necessarily overruled.
Yes.
And that's, I think, the way it's said, that what Lady Justice Arden is saying is that Lord Justice North was saying you can't have user damages for non-proprietary torts.
That's exactly how it's put. And I would accept that Lord Justice North may have regarded user damages as restitutionary. Lady Justice Arden may have done as well, because, of course, at this point, the leading case was Blake, which adopted a restitutionary analysis.
Well, I'm not sure that's the way. I'm not sure the way it's being analysed by Lady Justice Arden. She's not looking at what they are. She's looking at what you can't have, other than compensatory damages.
Indeed, my lord. But
sorry, I put that badly. What she said, what she regards it as, is a finding that you cannot have anything other than compensatory damages, and that must include user damages, not least because that's what they were considering in WAS.
Yes, indeed. But if we just look at the final sentence, which your lordship identified, where it says damages assessed on a purely compensatory basis. If Lady Justice Arden is saying that you cannot have user damages, she can only have said it on the premise that user damages are not quote unquote purely compensatory. That's the only way the argument works.
Yes.
And that's been rejected by the Supreme Court, which says that user damages are purely compensatory.
Well, in that sense, though, it's being used. There's no doubt that it was being used in Was, and Lady Justice Arden is using it as purely compensatory, in contrast with user damages.
Sorry, would your lordship mind putting that to me again? I just want...
Although the Supreme Court, in one step, said that user damages are another form of compensatory damages,
Yes.
the sense, that's not the sense in which it's being used in Was or by Lady Justice Arden here. She is using the term purely compensatory damages in contradistinction with user damages. And we know that because she's just referred to what Lord Justice Norse has said, and we know what Lord Justice Norse was dealing with.
Yes. But in a sense, that's a point in my favour, not a point in my learned friend's favour, because if Lady Justice Arden is using user damages in contradistinction, as your lordship put it, to purely compensatory damages, that cannot survive one step, which says that user damages are and have always been purely compensatory, but were wrongly analysed as something other than purely compensatory.
Forgive me though, I think nobody's suggesting that the distinction between what are generally regarded as straightforward compensatory damages and a different sort of compensatory damages has disappeared. And in fact, the whole point of one step is it says that you can't have anything other than usual compensatory damages in most cases.
Yes.
So I don't think the distinction hasn't gone. It's only a matter of terminology then, isn't it?
Well, with respect, I'm not sure I'd accept that, my lord, because if we just go back for a moment to the bottom of page 177 in the same paragraph, where Lady Justice Arden introduces this discussion, she says, Lord Justice Norse and Was regarded the underlying rule as a general rule only. She then says the exceptions to it are those he specifies. So just pausing there for a minute, Lady Justice Arden in this paragraph is therefore dealing with exceptions to Lord Justice Norse's first general rule. And that first general rule, as your lordships will recall, is the ordinary compensatory principle that in tort you put the claimant in the position in which you would have been had the wrong not been committed.
Yeah.
What we know from one step in lawyer, and this is why in my submission it's more than terminology, user damages are an application of that principle, not an exception to it. Lord Reed says that in paragraphs 30 and 91. Lord Leggett says that in paragraph 156 of Lloyd. That means the Supreme Court has now said that what we are calling user damages is an application of Lord Justice Norse's first general rule in Was, namely that damages in tort are...
But of a different kind of damage and by a different method.
I accept that, but they're not an exception to the compensatory principle. They're a different... But if they're not an exception to the compensatory principle, then this whole paragraph is founded on a premise which the Supreme Court has rejected, namely that they are an exception. Because if one looks at what Lady Justice Arden is doing here, she is saying, in order for Devonish to win, namely get an account of profits, you have to bring yourself within the exceptions to Lord Justice Norse's first general rule. You can't do it because this is a non-proprietary tort, and you can only have exceptions to the general rule of compensation for proprietary torts. That doesn't work in relation to user damages, because we now know, although we didn't know at the time, that user damages do not require any exception to that normal compensatory rule. They're an application of that rule, albeit by a different method. That is why, in our respectful submission, if para 76 means what my learned friend says it means, it doesn't survive one step or lawyer, then it's not actually surprising, because if one looks at earlier passages in Lady Justice Arden's judgment, the foundation for 76 is Blake, and Blake is what the Supreme Court rejects.
It's all right difficult because one step confirms the distinction and confirms when they are and aren't available. So it seems to me we are in a slightly unreal world here.
When your lordship says distinction, your lordship means distinction between
the usual compensatory measure and user damages.
But one has to distinguish between the legal nature of the principle and the method by which you give effect to it. So I respectfully agree with your lordship that one step says that user damages involve a different method of compensation. You looked at para 30 that says it. But
Not a different method, it's a different type.
yes, but it's still compensatory in nature, not
Different
restitution.
type assessed by a different method. You keep saying it's a different method. It isn't just a different method. It's a different type of damage which you assess by a different method.
I wasn't intending to disagree with that. I respectfully agree with that. My submission is, yes, it's a different type and a different method, but it's compensatory in nature. What matters for our purposes is not what type of damages it is, not what method you do it by, but what is its legal nature. Is it intended to compensate the claimant for loss or strip the defendant of his gain? That is really the critical question, and that's what Lady Justice Arden's grappling with in 76, because Devonish, by the time the case comes to this court, is not seeking compensation for its loss, it is seeking to strip the cartel of its gain. So Lady Justice Arden is asking herself, in what circumstances in the law of tort is a claimant entitled to a gain-based remedy? She says the answer to that question is in VAS, which is dealing, I accept, with user damages. But this only works on the premise, my learned friend's argument only works on the premise, that both Lord Justice North in VAS and Lady Justice Arden in Devonish regarded user damages as a gain-based remedy, by which I mean a remedy designed to strip the defendant of his benefit as distinct from compensating the claimant for his loss. It is that step in the analysis which is no longer good law after Lloyd and one step. And the fact that compensation occurs through a different method and is of a different type doesn't affect that. Because what matters is not, is it a different type or different method? What matters is it gain-based or loss-based? My learned friend's argument only works if it's gain-based, and that's what the Supreme Court disagrees with in one step in Lloyd.
What difference does it make to its availability what its juridical basis is?
Well, it makes, in our submission, a fundamental difference because historically, going back 150 odd years, the availability of gain-based damages has been tightly controlled. I mean, that's why Blake was a path-breaking case, because before Blake, the general understanding was you cannot get gain-based damages for breach of contract. Lord Nichols in Blake said there's no longer any such absolute rule, but in exceptional circumstances you can get them. Then the question became, do we do the same thing in tort? Lady Justice Arden says, no, we can't because of VAS, but none of this makes sense if the particular remedy we are concerned with is in fact not a gain-based remedy, but is a loss-based remedy. Because if it's a loss-based remedy, you just apply the normal compensatory principle, which is the principle in Livingston and Royard's Coal Company. You put the claimant in the position they would have been in had the wrong not been committed.
But forgive me, but we know from one step that nevertheless you do not have user damages in non-proprietary torts.
Well, I'm going to deal with that, my lord. With respect, I don't accept that. We say one step doesn't say that. What one step says is both in the law of contract and in the law of tort, you get user damages if the defendant wrongfully interfered with a right to control the use of a valuable asset. It doesn't matter what the source of the right is, whether it's a proprietary tort, a contract, a statute, it doesn't matter. Indeed, one of the problems, jumping ahead slightly, but it's actually helpful to do it now. In Lloyd and Google, the only reason why the claim for user damages failed was a point of statutory interpretation which doesn't concern us, about Section 13 of the Data Protection Act. But there's a passage where Lord Leggett recognizes that if that point of construction had been resolved the other way, then user damages could in principle have been claimed, which is actually inconsistent with my learned friend's argument that one step confines user damages to proprietary torts. Because of course the cause of action in Lloyd was under legislation. But I'll take your lordships to one step to try and make that good. But the point I make at this stage of my argument is that if para 76 of Devonish means what my learned friend says it means, then it doesn't survive one step or Lloyd. That's our third point about why we say Devonish is not binding if it means what my learned friends say it means. Our fourth point is this. Even if I'm wrong about all my prior points, so even if your lordships were to take the view that Devonish's authority that you can't get user damages for a non-proprietary tort there is subsequent and higher authority to the contrary, namely Gulati and Lloyd and Google. We can take it just from Lloyd because it refers to Gulati. Lloyd is at volume 1, tab 13, page 350. And could I ask the court please to go to page 398? Lord Leggett says this at para 141, a claim in tort for misuse of private information based on the factual allegations made in this case would naturally lend itself to an award of user damages. The decision in Gulati shows that damages may be awarded for the misuse of private information itself on the basis that, quite apart from any material damage or distress that it may cause, it prevents the claimant from exercising his or her right to control the use of the information, nor can it be doubted that information about a person's internet browsing history is a commercially valuable asset. Now, the tort of misuse of private information, which Lord Leggett says lends itself to an award of user damages, that tort is not a proprietary tort, because information does not constitute property in the strict sense. So if Devenish does restrict user damages to proprietary torts, as my learned friends contend, that would be inconsistent with both Gulati and Lloyd. And while my learned friend yesterday relied on the fact, your lordships will recall the submission being made, that Gulati doesn't use the language of user damages, but Lloyd does, and it is of some interest that in Lloyd, Lady Arden, as she had by then become, agreed with Lord Leggett's judgment. And one can see that at page 359, where Lady Arden is recorded as having agreed with Lord Leggett's endorsement of Lady Justice Arden's judgment in Gulati. Now, while we have Lloyd open, there's perhaps another point I can quickly make to avoid having to turn it up again. At various points in her submissions yesterday, my learned friend sought to draw a sharp distinction between the taking of property on the one hand and the acquisition of it under a contract, the terms of which are objectionable or wrongful. And she sought to persuade your lordships that you can never get user damages in the second category because you have in fact consented to the taking of property. My Lord Justice Phillips pointed out yesterday, and we respectfully adopt that observation, that that is difficult to reconcile with some of the broad statements of principle in one step itself, including the statement of Lord Shaw. But it's also inconsistent with Lloyd, because if we look at para 139 on page 397, user damages is the name commonly given to a type of damages readily awarded in tort where use has wrongfully been made of someone else's land or tangible movable property, although there has been no financial loss or physical damage. The damages are assessed by estimating what a reasonable person would have paid for the right of user. Damages are also available on a similar basis for patent infringement and other breaches of intellectual property rights. Following the seminal decision of this court in One Step and Morris Garner, it is now clear that user damages are compensatory in nature. And then this is the bit I rely on, their purpose being to compensate the claimant for interference, not taking away or deprivation alone, interference with the right to control the use of property where the right is a commercially valuable asset. And in our submission, that is, with respect, a useful encapsulation of the principle that now determines when user damages are available. Has the defendant wrongfully interfered with the right of the claimant to control the use of property or some other identifiable asset? If the answer to that question is yes, user damages are at least arguably available. I don't need to go further than that, and it is irrelevant for this purpose that the right comes from a statute. And it is irrelevant whether the statute, the right is characterized as proprietary or not. So that's point number 4, and I apologize for taking it at some pace. But point number 5 is this. There is a different inconsistency, in addition to the one I've already identified, the inconsistency between their interpretation of Devonish and Gulati lawyer. There's another inconsistency. Everyone, I think, agrees that what Devonish does say is that you can't get restitutionary remedies, such as an account of profits, for a non-proprietary tort. That's what Lady Justice Arden said. But even that is inconsistent with the subsequent Supreme Court decision, the Hopcraft case. Because in the Hopcraft case, and I'll go to it in a minute, what the Supreme Court said is you can get restitutionary remedies in the tort of bribery, which is not a proprietary tort. Hopcraft is a Authorities Volume 5, tab 52. Tab 52. I apologize, we should have put in the reported version in the bundle. It has been reported, this case. Not sure why this version is in the bundle, but the paragraphs I rely on are the same.
We've got the neutral citation, so that's all that matters.
Yes, I'm grateful, my lord. Page 2123. 2123. Paragraph 227, the Supreme Court says, if the appellant's case that the tort of bribery should be abolished is rejected, which in the event it was, their fallback position is there should be no automatic right to recovery of the bribe. They raised this point with some diffidence. 3 submissions were advanced. Then 229, as Mahesan and cases following it make clear, the basis of the common law entitlement is money had and received, or what would now be termed restitution. As explained at para 150 above, the remedy is an example of restitution for wrongs. As Sir Jack Beatson stated in FM Capital and Marino, while over the years there have been a number of ways of conceptualizing the obligation of persons to make restitution of bribes, today it is generally regarded as an example of restitution for wrongs, where the cause of action is the wrong and not unjust enrichment. Pausing there, the reason why Hopcraft is significant is if you just think of a normal, I mean, one shouldn't really use the word normal about bribes, but if you think of a standard bribery case in the Commercial Court of the Chancery Division, the allegation usually is you paid the middleman some $10 million because you wanted him to influence his principal to give you a contract of some kind. That is a tort, because the Supreme Court rejected our submission in Hopcraft that the tort should be abolished. So there's a tort of bribery, but it's not proprietary. You're just paying money to somebody's agent because you want to corrupt them. And there is an automatic right for the victim to recover the amount of the bribe from the briber. And what the Supreme Court is saying in para 229 is that the cause of action for that remedy to get the amount of the bribe back is restitution for wrongs. It's a gain-based remedy. And this itself derives from a long line of House of Lords and Court of Appeal authority going back to 1890. So it's very difficult.
So it's a right to recover the amount from the briber.
And from the briber, yes.
And not the recipient of the bribe.
And there are 2 remedies in the law of bribery.
From the person who pays the money and the person who receives the money.
Yes.
But you say only from the briber, or is it from both? When anyone receives the money?
You can receive it from, you have a cause of action against both.
So it's not restitution against the person who hands over the money because they don't have it anymore.
Yes, but the way it's been rationalized is that you would only go to the trouble of paying a bribe if you think it's going to benefit you. So there's an irrebuttable
in a sum more than the bribe.
Yes.
Okay.
And sometimes that will turn out not to be the case.
Yes, quite. Okay.
But what the Supreme Court says is that there are policy reasons why there is an irrebuttable presumption. We can see that actually at paras 232 and 233, where they refer to this and they say the reason for the irrebuttable presumption is the law's strict approach to bribery and so on. But my point for present purposes is a narrower one, which is the juridical nature of this remedy is restitution, not compensation, but it's restitution for a non-proprietary tort, because bribery is a tort. It's not an equitable cause of action, this particular aspect of the case. So again, to the extent Devonish says what my learned friends say it says, it's inconsistent with subsequent Supreme Court authority, in which case it can't be binding. That's our 5th point. Our 6th and final point on Devonish, if we need it, which will only be the case if we are wrong about all of our prior points, is that a further exception to the doctrine of precedent is engaged the so-called manifest error exception, which exists, albeit I would entirely accept that it is not to be invoked lightly. It is only, as Lord Justice Arnold put it recently, in rare and exceptional cases where the error or slip is truly manifest, can the court decline to follow otherwise binding authority of this court. And just to give you a reference, Mercy Global is the case. I think my Lord Justice Phillips was also in that case. Mercy Global is Authorities Volume 4, tab 45. And this point is addressed by Lord Justice Arnold at para 32 at page 1717. As we read, perhaps we should just look at that.
But you say that if there's manifest error, you're not bound to follow the precedent.
No.
And the question, what do you say the manifest error is?
I was
here?
just going to come to that. It's in para 71.
We'll assume that you're right, that there is the jurisdiction.
Yes, okay.
What's the manifest error?
So there are three of them. I want to focus on one in the interest of time. It's in para 71 of Devonish. That's co-bundle, tab 8, page 175.
You don't mean core bundle.
Authority.
I'm so sorry. Authorities, volume 1, tab 8, page 175. So, my lords, just picking it up in para 71, it's really, the penultimate sentence says, Lord Justice Norse and Lord Justice Nichols both gave reasoned judgments, and the third member of the court, Lord Justice Mann, agreed with both judgments. Then this sentence is what we respectfully submit is the manifest error. Accordingly, this court is bound by the ratio of either of the reasoned judgments. You see that in the final sentence of 71. Accordingly, this court is bound by the ratio of either of the reasoned judgments. Now, before I explain why we submit that's a manifest error, this sentence is actually critical to Lady Justice Arden's reasoning, because you'll recall that in the bit of the case on which my learned friend relies, para 76, it is only the judgment of Lord Justice Norse and not that of Lord Justice Nichols, which Lady Justice Arden considered to be binding. And absent binding authority, she would have accepted, or at least was inclined to accept, that Blake had liberalized the restrictions on the availability of restitution remedies. So it's important in our submission to ask whether this proposition that the court in Devonish was bound by the ratio of either Lord Justice Norse or Lord Justice Nichols is correct. We say it's not, and that is because, unfortunately, a case on this point does not appear to have been cited to Lady Justice Arden, and that is Gold and Essex County Council. What it says, and I'll go to it in a minute, what it says is that if in this court you have two reasoned judgments which adopt different reasoning, and the third member of the Constitution says, I agree, as sometimes happens, without identifying any one judgment with which they agree, then subsequent courts are not bound by either of the judgments. They're only bound by the judgment which contains the narrower ratio. And in our case, that would be Lord Justice Nichols, because he decided VAS on a much narrower basis than Lady Justice Arden. But can I just show your lordships the Gold case? Gold is at Authorities Volume 1, tab 2. Again, just to give your lordships the context, very quickly to summarize the facts. What happened in this case was a 5-year-old girl named Ruth Gold was taken to hospital to see a dermatologist. And she was treated by a radiographer named Mr. Mead, who was employed under a contract of service with the hospital. Mr. Mead treated Ruth Gold negligently. Her face was disfigured. To modernize, the solution seems obvious. The hospital is liable for the negligence of its radiographer. But it wasn't as obvious then, because there was a previous Court of Appeal decision called Hillier's case, in which two judgments were given, but the general understanding of that case was that a hospital is not liable for the negligence of its employees, provided it had taken reasonable care in recruiting them. So as long as you recruit competent people, if they make a mistake in the operating theatre, I mean, obviously that's not what the law is now, but there was a perception that that was the law then, so the claim actually failed. Ruth Gould's claim failed at first instance. Mr. Denning KC, who appeared for her in the Court of Appeal, sought to persuade this court that it wasn't bound by Hilliard's case, and that's why it's relevant to our case. And if we go, please, to page 12, sorry, not page 12, page 17, I apologize, page 17, the judgment of the Master of the Rolls. Picking it up, at the top of the page, there's a reference to Hilliard's case. Then the Master of the Rolls says there were two reasoned judgments in that case, those of Lord Justice Farwell and Lord Justice Kennedy. Lord Cousins-Hardy, the Master of the Rolls, agreed that the appeal should be dismissed for the reasons contained in both judgments. This, as the history of this class of case has proved, is unfortunate, since the reasons given in the two judgments differ in quite important respects. The judgment of Lord Justice Farwell is based on quite narrow grounds, that of Lord Justice Kennedy on propositions of a scope far wider than was necessary for the decision of the case. And then it's this sentence we rely on, it's marked with a red line. In a case where two members of the court base their judgments, the one on a narrow ground confined to the necessities of the decision, and the other on wide propositions which go far beyond those necessities, and the third member of the court expresses his concurrence in the reasoning of both, I think it right to treat the narrower ground as the real ratio. I accordingly look to the judgment of Lord Justice Farwell to discover what the case lays down as a matter of decision.
If the reasoning goes wider than the necessities, would it form part of a ratio anyway? I mean, it's regarded earlier in that passage as being obiter anyway.
Well, we respectfully agree, we say it wouldn't, but my learned friend relies on a case called Young-Sam, where Lord Justice Leggett says that you can't apply a very strict test of necessity, and you have to ask yourself what is the best or preferred justification given by the judge for reaching their conclusion. Now, I won't take time with it. We say there are various reasons why Young-Sam doesn't apply, but if you apply that approach to Hilliard's case, then both Lord Justice Kennedy and Lord Justice Farwell would have been ratio. Because what happened was, Lord Justice Farwell in Hilliard's case, he said that the reason why a nurse who's employed by a hospital is not liable for negligence in the operation theatre is that they are at that point under the command of the surgeon who's not employed by the hospital. So you almost regard them as not an employee while they're in the theatre. Lord Justice Kennedy went further and said the reason why the hospital isn't liable for the nurse's negligence is that the only duty of a hospital is to take reasonable care in the process of recruitment. Now that is wider, but it would, on my learned friend's approach, be ratio, because that is Lord Justice Kennedy's reason for allowing the hospital's appeal in Hilliard's case. And that is why we would suggest Lord Green in this passage uses the word real ratio. If you look just 3 lines from the bottom, he says, I think it right to treat the narrow ground as the real ratio. So one reading of this is, even if both Lord Justice Kennedy and Lord Justice Farwell are ratio rather than obiter, what a subsequent court is bound by is the narrower of the two judgments. And one can see, we would submit the rationale for that, my lord, because otherwise the doctrine of precedent could produce injustice and inflexibility, because it would tie the hands of a future court on a ground that went much further than what the earlier court needed to do. I mean, you could get to the same result by saying it's obiter. And if that's right, then we say we win. But if it is ratio, as my learned friends contend, then there's a manifest error in Lady Justice Arden's judgment in regarding herself as bound by the wider judgment, that of Lord Justice North. Now, the reason why I submitted earlier, this is quite critical.
I understand all this. I mean, from our perspective, on what's effectively a sort of an appeal from a strikeout type of application, whatever WAS says or doesn't say, isn't the critical question for us that assume it is as tight as it can be, whether they preclude further exceptions? I mean, isn't that it? So we've got to say, what is the position in competition law? Are we precluded, or would the CAT be precluded from saying that some form of user principle is applicable in a competition case because it's bound by WAS? And was WAS laying down an absolutely watertight, definitive list of cases where a user principle can be applied?
Yeah.
And we have Lord Justice North asking himself whether this is a case in which he says, should there be further
Yeah.
exceptions? And then you've got Lord Nichols saying the common law is pragmatic and we're in a state of development. But, I mean, for my part, I think it's hard to say that they were addressing themselves to bright line boundaries. And if not, then one way of looking is to say, well, the cat's going to have to grapple with it. They may be absolutely right, but it doesn't preclude the cat from looking at it and then deciding whether whatever sort of damages they come to at the end of the day are precluded in law. So the issue remains live. At the moment, it just seems to me the nub of it is whether they were laying down a boundary line.
Yeah. If I may say, we respectfully agree. Frankly, that is the short answer to the appeal. I'm just trying to meet all the points that are taken against me. But your Lordship's absolutely right, because if one analyses this in stages, if you take VAS first, it is very clear in our submission, not just to the summary judgment survival standard, but it's very clear for the reasons your Lordship just identified, that VAS is not laying down any exclusionary rule. Lord Justice Norse considers making a further exception. Lord Justice Nichols expressly says he's not identifying where the boundary lies. What my learned friends are seeking to do is to use Devonish to attribute to VAS something VAS doesn't actually say. And then to say your Lordships are bound by Devonish's interpretation of VAS. But that, in our respectful submission, is not how the doctrine of precedent is meant to work. I mean, if Lady Justice Arden misinterpreted VAS, then the court is free to say that, interpreting VAS for itself. And one of the problems with respect with Devonish, if it means what my learned friends say it means, is the apparent assumption that the exceptions identified in VAS are exhausted. It's unclear where that comes from. VAS doesn't say that. So we respectfully, I mean, this is not the sort of point which could result in strikeout. It's something, if they want, they can certainly run a trial, and then the cat will have to decide.
Well, Lord Justice Norse talks about the increasingly extended application of the user principle and the fact that it appears to have come about by accident rather than by design.
Sorry, I'm just going to turn that up.
Page 91, letter, just below letter A.
Page 91. Yes, by accident rather than design. Yes, indeed.
And then he says at the end of that paragraph, in a process of development, it's sometimes necessary to stand back from the authorities and ask not simply where they have come to, but where, if a further extension is made, they may go next.
Yes. Yes.
So it's hardly a full stop.
Precisely so. And frankly, that may be my best point, because if one, and indeed the chair asked my learned friend this question, which is, if you just start with VAS, can you extract from it this exclusionary rule for which you contend? And we submit the answer to that is very clearly no. So then the question becomes, if they are wrong about VAS means looking at VAS itself, can they use Devonish to say, oh, but Devonish construed VAS to mean what we say it means, even though VAS doesn't mean it and you're bound by it? But in our respectful submission, that's not an attractive conclusion, especially when it's put forward as binding authority. So that's really all I wanted to say, subject to the court, about Devonish. But with respect, we adopt and agree with the point my Lord Justice Green put to me, which is these are all interesting points, but they are for another day, they're not for strikeout. And that actually then takes me to issue 2, as I identified it yesterday, which is if Meta can't persuade you, there's clear binding authority in its favor, is there some other reason why the tribunal was wrong to permit the amendment? Now, I want to start with a threshold point, as we see it, which my Lord Justice Phillips put to my learned friend, which is, what is the test for amendment in a situation of this kind, and what is the test for appellate interference with a decision to give leave to amend? I want to address that.
Really, I mean, that's pretty familiar territory.
Yeah.
It is. I was just going to make one point, if I may, about the Begum case, because there's one.
Why don't you make all your best jury points?
I hope your Lordship will think it's more than that.
Well, we know the principles. We're very familiar with those.
No, indeed.
What are these other reasons?
So there's only one dispute on the law between my learned friend and me, I think. My learned friend says that the principle that the court will not grapple with difficult legal points in a novel area of the law, she says that principle is confined to cases where facts might emerge at trial which are capable of affecting the answer to the legal point. She said a number of times, you know everything you need to know, we're going to be back here in 2.5 years, why don't you grasp the nettle? Now, That's the dispute between us. We say that's wrong as a matter of fact. There are facts which may influence the answer, but it's wrong as a matter of principle, because there is in our submission a broader, more fundamental reason for the court's unwillingness to determine novel points of law summarily. It's not merely that the correct answer to the point of law may depend on the facts found at trial, but a more general principle that difficult legal points should be decided on the basis of actual facts and not assumed facts.
Well, this is Lord Brown Wilkinson in 2 House of Lords cases.
Yes, and Begum is a very good illustration of it, because what I was going to show your lordships is, if you look at Begum, novel claim extending Donoghue and Stevenson for personal injury against a third party. But the critical thing about Begum is, all the pleaded facts were assumed to be true, and the case proceeds on the basis that the claimant's case is not going to be any better at trial. Lord Justice Coulson says, despite that, it is inappropriate to resolve this summarily. And there's a very helpful, if I may respectfully say, explanation of it in a judgment of Lord Briggs in Vedanta, where he says, if you determine these difficult points summarily, you're doing it on the basis of abbreviated facts. That's the word Lord Briggs uses, abbreviated. What he means by that is, the only facts you will have to go on in a case of this kind are the facts which are pleaded. But those facts are inevitably going to be more high level and less granular than the detailed factual findings that a trial judge will make after, in this case, a 10-week trial, about the quality of matters conduct and so on. I don't know if I need to, but can I give the court the reference to
Why don't you give us the reference? First of all, Begum, yeah?
Yes, it's Begum, and the key passages are paragraph 23, page 412, which picks up the authorities my Lord Justice Phillips mentioned, Lord Brown Wilkinson. Paragraph 24.
Where is it?
Sorry, authorities, volume 1, tab 14, page 404 is where it starts. Paragraph 23 is at page 412. Which refers to the Lord Brown Wilkinson case. Paragraph 24 refers to the point I just made, Lord Briggs, who says abbreviated or hypothetical facts. Paragraph 36 at page 415 notes that in that case, all the relevant facts had been assumed in the claimant's favor. The assumptions, therefore, would appear to represent the respondent's case at its highest. It is not easy to see how it could be materially improved at trial. But then at paragraph 71 at page 424, Lord Justice Coulson said, despite that, this is a novel point at the forefront of the development of the law of negligence, and it would be inappropriate to strike out the claim based on assumptions in the absence of any actual findings of fact. So that's Begum. Now, one of my learned friend's answers to this point yesterday, when it was put to her, was that this would be very inefficient, is how she put it. She said, we'll all be back here in 2.5 years making the same arguments. But, my lords, there are 2 difficulties with that submission. The first is we may not be back here, at least about this point in 2.5 years, if our conventional damages claim succeeds, because then the user damages amendment may become academic. But second, even if we lose on conventional damages but win on user damages at trial, if we are back here in 2.5 years' time, we will be here with the benefit of a detailed judgment from the CAT following a 10-week trial containing granular factual findings about matters conduct and about various factual matters that may bear upon the availability of user damages, such as the quality of the consent allegedly obtained by Meta from users in collecting the off-Facebook data. So we do say that if Meta can't persuade the court that there's clear binding authority in its favor, ruling out the possibility of extension, that is the end of this appeal, because everything else is a matter for trial. And that's how we put it.
Just can I ask you a question in relation to the facts?
Yes.
We've been trying to work out what sort of a trial it would be, and presumably for the purpose of seeking to establish abuse, the CAT will be looking at a range of different pieces of evidence. which would include financial data arising out of meta disclosure about, which might give a very clear indication of how they divide up the value between Facebook and off Facebook data, what benefit they get from it, what advertising revenues come from it, how much of that is how much of the costs are attributable to paying or not paying for the data, and so on and so forth. You could quite easily, so it seems to us, come to a conclusion about the quantum of an abuse without having to go into counterfactuals or without having to look at Nash principles. So it may be much, much simpler than one imagines, albeit that the evidence will be huge, complex, and will have to be synthesised. But the analysis of the abuse, which would then inform the loss, might not go down any of these byways and highways.
No, it all remains to be seen. As your Lordship says, it's hard to predict at this point, especially in a case that's as complex as this. But that, if I may respectfully say, is an important point, which also picks up on a point my Lord Justice Zacaroli asked me yesterday, which is, can you establish an abuse without a counterfactual? The answer is yes, and it's a point that's made by my Lord Justice Green, both in the Gutman case and in the judgment of this court in this very case, which picks up on Gutman. And I think the point my Lord makes there is some trading conditions may be inherently unfair, and you can tell that just by looking at the condition without having to engage in counterfactual analysis. I don't say that will happen in every case, but it can happen conceptually.
I mean, I think in this case, although one's peering into a fog, some form of counterfactual analysis might be required. But it may be, so for example, if it's possible to calculate the margins and the profits of Meta by looking at internal financial data, you may come to the conclusion that the amount of value which has been extracted is X.
Yeah.
And you would then say, well, X, which we've now deduced from internal disclosure, is a measure of loss because in a counterfactual we can assume that X would have been that which Meta would have paid in aggregate to the class for this data. So you theoretically superimpose a counterfactual at the end of the analysis, but it may be that that's about as minimalist as it would need to be. We just can't predict at this stage what would happen.
No, that's certainly a possible counterfactual, but I think the difficulty, the reason why we've had to make the user damages amendment and why we were permitted to do it is, Meta are going to be saying at trial that even if we have established the abuse, and we might be able to do it without reference to a counterfactual. So let's take our pleaded case. I showed the court yesterday. I think it's S13 in the claim form and 14, where we say unfair trading condition. Before you even get to unfair price, we say unfair trading condition because you didn't obtain consent and various other things, choice architecture. If we win on that point, we have established an abusive dominant position. There's then a separate question about causation and remedy, which are separate questions. Meta will come along and say at trial, in the counterfactual, we would have chosen not to pay you because we don't pay for data. Therefore, you get nothing.
Well, I think, and if I've understood it, what they're saying is it's quite impossible for us to make a payment of 46 million people. Now, this data only really has value in its aggregated form. Therefore, in a counterfactual, we're not going to do 46 individual negotiations or payment schemes, whether that's true or not.
That's certainly one of the points they take, but I think they also take perhaps a broader point, which is they say, we just don't do this sort of thing. We've never negotiated with our users.
No.
And we will default to some other model. It's not even pleaded. There's no positive case that's pleaded, and they need to plead it. But the point is, if they were to plead what my learned friend gave us an example yesterday, where she said, we might offer users the option to pay to avoid their data being collected. That even if that's what they would have done in the counterfactual, it doesn't change what actually happened in the actual world, which is an abusive dominant position on this hypothesis by imposing an unfair trading condition. Now, at that stage of the analysis, our case, which is what the tribunal has permitted us to run, is that the users suffered a real loss in that their data has been taken wrongfully on this hypothesis, and that's precisely the sort of thing for which one step in Morris Garner says a possible remedy is user damages, which is why the amendment may be relevant. Indeed, if I can take the example my Lord Justice Zacaroli gave me yesterday, which is that...
Sorry, just before I do that, coming back to counterfactuals, I mean, in all the excessive pricing cases that we've been dealing with over the last year or so, the primary case is not based on a counterfactual. It's based upon A, the calculation of cost, B, the price, the average selling price over cost, and whether or not there's a justification for it. defendants, Jen, come in and say, actually, the price was fair because in a comparable, in an alternative hypothetical market, we can see the price would have been X or
Yes.
Y. But
Yes.
the actual abuse is not established by reference to a counterfactual, nor is the subsequent civil claim for damages.
We respectfully agree, and if I can give you a lordship references, I was going to go to this, but this point that you don't necessarily need a counterfactual to establish abuse is made by my Lord Justice Green in this case from Metter's unsuccessful appeal. Maybe I should just show you that. It's Authorities Volume 4, tab 47. Page 1741. So this is Metter's unsuccessful appeal from the certification decision, which allowed this claim to proceed. And if we go to page 1753, please, paragraph 30 of the court's judgment. My Lord said, secondly, and in any event, this is an area of law which is par excellence new and evolving, and which also we rely on in support of why this is not really super strikeout. The use of data as a proxy for monetary payment is a rapidly increasing phenomenon of modern digital life, and as such it is generating a new range of legal issues. As was pointed out, in Flynn Pharma, the law is flexible and there is no single test which must necessarily be applied to determine abuse. In Gutman, paragraph 102, the court referred to established case law which made clear that an abuse could be assessed by reference to the counterfactual where there was no dominance, but it could also be determined by looking at the disputed term itself to evaluate whether in and of itself it was unreasonable or disproportionate. And similar points are made in Gutman, just to give the court a reference, that's paragraphs 96, 99 and 100 in Gutman, which is Authorities, tab 43, page 1623. So that's why, in the light of that, if I can come to the example my Lord gave me yesterday, which is what happens if the tribunal were to find that an abuse is established, say because of the unfair trading term, but in the counterfactual, Meta would not have paid anybody for the data, but some users would have moved to a different social network, I think was the example, which doesn't require them to part with their data. Now, that may well be a plausible counterfactual. It remains to be seen if Meta were to plead and prove this positive case. But let's assume in that counterfactual that Meta would have levied this fee if you don't want your data to be collected. But assume that of the 46 million users whose data was actually taken, 10 million would have shifted to a different social networking model. In that scenario, the 10 million people who move from Meta to, I don't know, X, would not, on Meta's analysis, be entitled to any conventional damages because it will be said you suffered no loss, but it is also said that you don't get user damages because competition law does not give you user damages and it's conventional loss or nothing. But that, in our respectful submission, is a surprising outcome, which is contrary to the purpose of Section 18 of the Competition Act, because it would mean that 10 million users whose data on this hypothesis was abusively taken by Meta have no remedy at all under competition law. And my learned friend accepted that when it was put to her in argument below, that's Supplemental Bundle, tab 11, page 196, and appeared to accept it again yesterday at page 98, lines 10 to 13. And that actually, that example, that counterfactual illustrates why the one-step wrongful use principle has a role to play in competition cases, not in every case, but in a case of this kind, where the wrong done, the competition law wrong itself involves interfering with somebody's right to control their data or some other identifiable asset. And we submit at a minimum that must be arguable, which is really all.
Can I ask you a question in relation to that? If WAS applies, then, as I understand it on the terms of WAS, you don't get any form of user damages. You get nominal damages and an injunction. If the CAT were to say we're bound by WAS, but we'll grant an injunction under Lord Keynes's Act, we can grant damages in lieu of an injunction.
Yes.
Where does that take one?
So when you
First of all, what would be the impact of the injunction on the business? Because it may be thought it would be so catastrophic that neither the users nor Facebook would want an injunction. And the court may say, well, we can grant damages
In
under
lieu.
Lord Cairns Act in lieu of an injunction, which would be on a user basis, wouldn't it?
Yes, so just taking that in stages, when your lordship says if the court is bound by VAS, I think what your lordship is putting to me is if the court is bound by VAS to hold that you can never get user damages for a competition.
Yes.
And obviously your lordships have my submission about
Yes. We're just trying to see where the argument goes, because I can go back to WAS, but didn't WAS say that in those circumstances the remedy is either injunction and or nominal damages?
Yes, and so then as
So
a
it's
lord,
really the question is injunction. What's the impact of an injunction being granted by the CAT?
yes,
Because it says it can't award damages.
yes. Well, so two responses to that. First, your lordship is right that whether an injunction is actually granted or not, there is a power to award damages in lieu of an injunction under Lord Cairns Act. But I mean, one doesn't know. I imagine Meta will probably contend that the CAT has no power to do it. I mean, we haven't pleaded it, so that point hasn't been fought out. For our part, we say the CAT does have power to
Well,
award
the CAT's got a
damages.
discretion under its own rules to grant an injunction by way of a remedy.
Yes, but I think they will take the point because of the language of Section 47A and 47B of the Competition Act. They will take the point that you can only get damages in lieu in the High Court and not in the CAT because of the way the provision is worded. I mean, I don't want to sort of...
I think the provisions under the CAT rules for orders to be made. Anyway,
I mean, I don't want to identify arguments for that.
I don't want to get into another pleading point, but just where does this end up if the CAT can order an injunction in lieu of damages?
But which was my second point. If the CAT does have power to...
Or an order, let's say it's not, say Lord Cairns only applies to High Court, but under its own procedural rules,
Yes,
to grant a remedy, a direction,
yes.
which would prima facie be that Meta cannot extract the data without consent and or payment.
Well, we would submit that supports us on this appeal because if the CAT has that power, it would be surprising if it doesn't have the power to grant user damages applying the one-step and Morris-Garner principle. Why does one have to resort, I would ask rhetorically, to a procedural rule in circumstances where substantive law, namely one-step and Morris-Garner, provides a remedy for me in circumstances where some identifiable asset is wrongfully extracted by somebody in breach of Section 18? So the damages in lieu point isn't before the court because we haven't put it forward, they haven't responded to it. But we respectfully agree that it would be surprising if the CAT has that power, but somehow user damages under the one-step principle are wholly foreign to the Competition Act, which is the case my learned friends are advancing. And my Lord's example...
We're just assuming that if you're wrong on all that, and the CAT in paragraph 15,439 says that in relation to damages, WAS binds us.
Yes,
But we note from WAS that we have the power to grant an injunction.
yes,
And under our rules,
yes,
we can grant orders and directions.
Yes.
And we would be minded to grant an order along the following terms.
yes.
Could we have the parties' views on this, please?
Yes, and that may be a point that has to be fought out at trial, in addition to the VAS point, because as your Lordship says, it all arises if I'm wrong about everything else.
Yeah.
But certainly our position, I would be that the CAT has that power, but
But if they did, and they used it, and they sent out a draft order, what would the parties' response be? On one view, it's potentially catastrophic to the service. Facebook
because of the injunction,
Yeah.
unless they only grant damages in lieu.
But either Facebook then comes back and says, we'll make a payment in lieu of an injunction,
Yes,
or the order is made. I mean, not a terribly satisfactory outcome to do that, but
no,
if the CAT has got to remedy what it finds to be an abuse,
yes,
and it feels it's its duty to remedy an abuse,
Yes.
and it can't do so through damages,
yes. Then
Dot, dot,
that
dot,
would be
then
that,
what happens?
Yes, indeed. I mean, I don't know what they'll say about that, but I see what your Lordship means. What would be odd is for the CAT to find there is an abuse, there is a loss, but no remedy, which is their case. And that's why I keep coming back to my Lord's example, because it shows how you can end up in that world. Abuse, loss, no remedy, which is exactly the opposite of what, as my Lord explains it in Gutman, the purpose of Section 18 is, which is to protect consumers from exploitative conduct of this kind and to remedy losses caused by such conduct. And one thing we know after one step in Morris-Garner is if somebody wrongfully interferes with my right to control a valuable asset, that is a loss. It's not some fictional or hypothetical loss, it is a loss. So we, for our part, we say one way or another.
Well, this is what I mean. It's a begging question, but you say this is paragraph 30 of one stop. If you've got a
Yeah.
yeah.
Yeah,
All right.
and just on the unfair price point, because the court discussed this with my learned friend yesterday, it's not academic even there. It's slightly difficult to predict exactly how it will all turn out. In a way, that shows why this is all a point for trial. But one version of our unfair price case is that we bought the Facebook service and they charged us a price for that service in the form of the off-Facebook data. Let's assume that that price is unfairly high, which has to be the assumption on this appeal. Now, one possible analysis is if the fair price to charge for the Facebook service is no data at all, then one possible analysis, which my Lord Justice Green put to my learned friend at an early stage yesterday, is that you then just calculate the difference in value or the value of the off Facebook data, which is the excess in price, and Meta's got to pay up, and it is irrelevant whether it would or would not have paid. But what they're going to do, they're going to come along at trial and say that even if the off-Facebook data is an excessive price and the fair price is no data, you get nothing because we would in fact have chosen not to make a payment. One possible answer to that is that's just wrong as a matter of the law relating to unfair prices, but they don't accept that. So, which is why user damages, even for the unfair price case, has a role to play. Because if they're right about that, they're not going to accept before your lordships they're wrong about that.
No, we understand that. That came out of the analysis and discussion yesterday.
Well, precisely so. So the only point
I'm just looking at the time, and we must make sure that Mr. Mitri has got a response.
Yes.
I think it's a fair amount for her to grapple with.
No, of
How
course
are you
not.
doing?
I'm on track. I mean, what I'd agreed with my learned friend, subject very much to the court, was that I'd stop at 12:30 and she'd have 30 minutes. But if your lordships would prefer that she should have longer, I'm entirely in the court's hands, what it would find helpful.
How much more have you got to do?
I've got to deal with one step, my lord's point, Lloyd Google, but that's pretty much it.
Say, well, why, I mean, give us your best hits on those points. we do know the cases.
Your lordship,
We
that's,
know
yes.
the arguments.
Indeed. One thing I promised to do yesterday, which I haven't done, is I mentioned that there was an RFI served by Meta about consent, and we've got copies for your lordships.
Oh, yes.
And that may also be relevant to this question of what factual findings at trial may bear upon the availability of user damages. Do you have a copy? I'm sure we do.
I'm so sorry.
No, don't worry. I'm usually the one who does that.
Thank you very much.
So this is a fairly recent RFI served by my learned friends. We've responded to it. And if I could ask your lordships, please, to go to internal page 7. The page numbers are at the top of the page, not bottom. We pleaded little 5 at the bottom of the page. Meta's position in approach to its T's and C's, its policies and its choice architecture resulted in a lack of transparency and a lack of fairness for users as regards their personal and sensitive personal data, including depriving them of the conditions in which it is possible for them to consent to Meta's processing. Then at page 9, we plead in capital A, users do not, and could not compliantly with Article 6 and 7 of the GDPR, consent to the collection, transfer, and use of all Facebook data. And then in D, we plead, Meta deprived and continues to deprive users of the ability to refuse or withdraw consent, meaning any consent was not and is not freely given. Now that is significant because contrary to what my learned friend submitted yesterday, there is an allegation in this case that the off-Facebook data was collected and used without effective consent. That's alleged and must be assumed to be true. And if one recalls Lord Shaw's formulation of the principle for user damages, quoted in one step, where you ride a horse against the wish of the owner, we would say likewise here. And indeed, my learned friend's characterization of this case as a complaint about the terms of a bargain, one of the themes of her submissions, that itself is a contested view of the pleaded facts, and we would suggest is not a premise on which the claim could be struck out. So that's the RFI. Very quickly on one step, my Lord Justice Phillips asked me whether one step says that you can only get user damages for proprietary torts. In our respectful submission, it doesn't say that. Indeed, without wanting to go back to it, very important to remember the historical context against which the case comes to the Supreme Court in one step, and the reason why they constitute a panel of, I think it was 7 or 9. The reason is there'd been a debate for 50, 60 years about whether user damages are restitutionary in nature or compensatory in nature. Conflicting authorities going in both directions. I think it's para 1 or para 3 of Lord Reed's judgment. He says that this appeal was the first opportunity for the highest court to identify, quote unquote, the theoretical underpinning of user damages. And that is...
That was a court of 5.
I'm sorry, my lord?
I thought...
It's a court of 5.
Oh, have I misremembered it? I'm so sorry, I assumed it was 7. I'm grateful to your lordships for correcting me. I apologize for that. What I was referring to was paragraph 1 at page 277. Lord Reed says that the confused state of the authorities, lack of clarity as to the theoretical underpinning of user damages, first occasion on which the issue has come before the highest court for decision. Now, that itself suggests that what the Supreme Court was seeking to provide in its judgment was that theoretical underpinning. In other words, a unifying principle that tells you when you get user damages and when you don't get them. And that unifying principle is not about proprietary rights. It is about the existence of a right to control some identifiable asset which has been interfered with wrongfully. That right could be contractual. And the court will recall yesterday, I refer to the Experience Hendricks case, where it's a right to control somebody else's property. And there's nothing in para 95 or anywhere else which says that in tort you can only get it for proprietary torts. Indeed, at page 302, para 95.1, Lord Reed refers to the rationale for such awards is that the person who makes wrongful use of property prevents the owner from exercising a valuable right to control its use and should therefore compensate him for the loss of value of the exercise of that right. He takes something for nothing for which the owner was entitled to require payment. So there's nothing here that says that you can only get it for proprietary torts. And indeed, One Step and Lloyd both recognize that you can get user damages for breach of confidence and equity, which is not proprietary, misuse of private information, not proprietary, patent infringement, not proprietary. So that's what we say about the proprietary tort limitation in One Step. My learned friend also took another point about One Step. She says that insofar as you can now get user damages for what she described, I think, as the adjacent causes of action, misuse of private information and so on, she says that's because those causes of action specifically protect some property or quasi-proprietary right, whereas competition law doesn't. Now, I'm not sure what specifically protects means. Ultimately, the question is one of substance, not form. The question the court is asking is, does the claimant have a right, whatever its source, to control some property or asset? Was that right interfered with? There's no specificity requirement in One Step or Lloyd or in any other case. Indeed, your lordships have my submission that Lloyd is, if anything, authority to the contrary. And perhaps finally, just to make good the submission I made yesterday, that the boundaries of user damages are not closed, even in what may be my learned friend's, the high point of my learned friend's case, certainly below, where she took the example of deceit or fraudulent misrepresentation, which induces the claimant to part with their property. And she said, you can't get user damages for that. There's no case that says that. There's actually a case which says, if anything, the opposite. And that is the Larrikin music case I mentioned to the court yesterday. Authorities, Volume 2, tab 31, page 822. Volume 2, tab 31, page 822. again, to save time, very quickly to summarize the facts. This case, an Australian authority, it concerns the copyright in an Australian nursery rhyme called Kookaburra Sits in the Old Gum Tree, written in 1934 by Marion Sinclair. The owner of the
I
copyright...
think we could all do a sing-along to that. Well, the elder members of this court. Looking around, actually, they might not include too many.
The owner of the copyright in Kookaburra was Larrikin, the claimant. In an earlier judgment referred to as the February reasons at paragraph 2 at page 825, the court had found that Larrikin's copyright in Kookaburra had been infringed by another song called Down Under, which had reproduced a substantial part of Kookaburra. That's para 2 at page 825. But what had happened was that the respondents, you see the names of the respondents at the top of the page, the respondents who were the composers of Down Under, or the recording companies, had made misrepresentations, and that's why I want to go to this case. They had made misrepresentations to the Australian collecting societies called APRA and AMCOS. First, that the performance and reproduction of Down Under did not infringe the copyright in any other work. And second, that they were entitled to the whole of the publishers' and writers' share of the income from Down Under. One sees that, and because of those misrepresentations, the collecting societies paid 100% of the income from Down Under to the respondents. And in the earlier judgment, the court had held that the representations constituted misleading conduct and a contravention of Section 52 of the Trade Practices Act 1974. One sees that at paragraph 5 at page 826. So the cause of action in Larrikin, which is why it's of some assistance, was a claim for damages for breach of a statutory duty. And the duty in question under Section 52 of the 1974 Act was a duty not to engage in misleading or deceptive conduct. So not proprietary even by analogy. It's just almost like our Misrepresentation Act. You can't engage in misleading or deceptive conduct. But the damages that the court awarded were user damages. And they were user damages for breach of a statutory duty, not copyright infringement. Again, we can see that at paragraph 5, where it says, page 826, there are damages under the Trade Practices Act for misrepresentations made by the respondents to collecting societies. And if we then go to paragraph 8, please, at page 826, the court says the parties agree that the percentage is to be determined upon the basis of a hypothetical bargain that would have been struck between a willing licensor and a willing licensee of the copyright in Kookaburra. The approach is in accordance with the principles normally applied for copyright infringement. And then applying that principle, the court found on the facts that if there had been a hypothetical negotiation between Larrikin and the respondents to license Kookaburra, that would have resulted in a payment of 5% of the income earned by the respondents from the collecting societies. That's page 859, paragraph 220 to 222.
So your point is that here the court awarded damages which are properly analysed as user damages for breach of a statutory duty which was non-proprietary.
Precisely so. And importantly, my lord, they did that even though the respondents' evidence was that they would not have been willing to make any payment to Larrikin. So that's para 98 at page 842. So if I can adopt the terminology my Lord Justice Phillips used yesterday when he said, is the point of user damages to prevent Meta from saying that Meta would not have played ball? Where user damages are available, the defendant can't defeat the claim by saying, I wouldn't have played ball. Here they were saying they wouldn't have played ball. Page 842, para 98, Mr. Hay made it plain he would have vigorously resisted payment of any or any substantial share of the income from Down Under to Larrikin. So that again shows that the boundaries aren't closed. If they want to say at trial this is all wrong, they can.
So what was the court's actual decision in this case?
You see that at para 220, page 859. Where it says 5% of the total amount is payable to Larrikin.
But where is the point of principle the court decided?
I rely on it only as an illustration that user damages are available or not ruled out for a statutory cause of action which is not proprietary. But your lordship is right, it doesn't grapple with.
But my understanding is from paragraph 8, the parties agreed that the percentage was to be determined on the basis of a hypothetical bargain.
That is fair, my lord. That's why I drew it to your
You're
lordship.
showing us an Australian case where the parties agreed that that was the basis.
I don't put it any higher
I
than to say.
understand that it's even worth the paper for our purposes. It's worth even the effort of turning it up. I'm sorry.
I understand that. I won't take it any further. I was just going to say the court appears to have regarded it as rightly made, but your lordships have the point. I don't think I need to say anything about the EU directive, which my learned friend relied on. It's just the same compensatory principle. So if you're right about English law, then the EU directive doesn't undermine our case. May I just have one moment, my lord, to check if there's anything else I need to cover? Unless I can assist your lordships with anything else, those are my submissions.
Thank you very much.
May it please your lordships. My learned friend in his submissions repeatedly emphasised that his task was not to establish that his client's claim for user damages is well founded in law, but that what he needs to do at this stage is persuade the court that it's arguable in law. And we agree that that's the question for the court. It is a pure question of law, and we say that this court can and should find that the claim for user damages has no reasonable prospects of success because it's not well founded in law. Now, the error permeating the class representative's argument is that she focuses consistently on the facts pleaded in this case rather than in the source of the rights or the cause of action. And you heard my learned friend say repeatedly that what matters is the substance rather than the source of the rights. And this is wrong, and it's a crisp point that we differ on. We say it's wrong, and I'm going to return to it shortly. But first I would like to address you in reply on Devonish, because my learned friend accepted that the question whether this court is bound by Devonish is a hard-edged question that the court can and should decide now. Now, my learned friend, you heard at the end of yesterday and for much of this morning, had a whole set of very detailed submissions on Devonish. But we say, in fact, the question is a simple one. Did Lady Justice Arden find that WAS constitutes binding authority, that user damages are only available in tort for the proprietary torts? Did she find that? Answer yes. That binds this court. My learned friend's main argument on Devonish is that it's not binding on this court because the Court of Appeal in that case proceeded on the basis that user damages are a gains-based or restitutionary remedy rather than compensatory. And he says, well, we now know in one step that, in fact, that's not right and that they are, in fact, compensatory. But this argument on proper analysis elevates semantic points about terminology into a substantive point without any proper justification. The terminology used by the Court of Appeal in Devonish was not germane to its decision. And in making his submissions, my learned friend elided the distinction which still exists and the distinction that was key to the Court of Appeal in Devonish. The distinction that was key being the distinction between, on the one hand, damages for pecuniary counterfactual loss, I'm going to call them conventional damages, and on the other hand, everything else, including user damages. That's the distinction that remains in the law, and we see that in one step, not only from paragraph 30, which talks about user damages being damages of a different kind, but also paragraph 93, which expressly contrasts user damages with conventional damages for pecuniary loss. And on analysis, my learned friend's argument about the labelling and the terminology does not provide a proper basis for concluding that Devonish is not binding. The court in Devonish obviously understood what user damages were as a matter of substance. It understood that an award of user damages was not an award of pecuniary counterfactual to compensate for pecuniary counterfactual loss, that it was an award made to reflect the use of property in breach of a right. I'm going to show you where it said all of those things. And as I say, the label, gains-based or restitutionary, was simply that, a label. It wasn't germane to the court's conclusion on the critical point for our purposes of the circumstances in which user damages are available. And that was the substantive point the court was concerned with. Now, can I take you back to Devonish? I know you've looked at it a number of times, but please indulge me, I'm not going to be very long on it. So it's behind tab 8 of the First Authorities bundle. And if we take it, please, from page 163. And let's look, please, at paragraph 36, letters E to F, where Lady Justice Arden says, that the user damages and route and park damages still have an element of compensation within them, in this sense that while there may be no actual loss, there are clearly cases where the law takes the view as a matter of policy that the claimants, if they prove their claims, are entitled to substantial compensation for the mere invasion of their rights. There's nothing wrong with that. That's completely consistent with what the Supreme Court says in one step. Then we see at 37G, damages for trespass to property, for instance, are awarded on the basis of market rent, even if the claimant would not have let the property vacant. At the same time, they can be described as compensatory. So Lady Justice Arden is recognising that they can be described as compensatory. And we can see, let's go on to paragraph 38 over the page. And this is key. What, however, does distinguish user damages from other compensatory damages is the fact that they are in general awarded because the defendant has made improper use of an asset of the claimant. In economic terms, there's been a transfer of value for which the wrongdoer must account. Now, pausing here, you can see from this that Lady Justice Arden, unsurprisingly, understood exactly what user damages are. She understood that they could be seen as compensatory in one sense, and she is making the distinction, which was the critical distinction in this case, between what she's called their other compensatory damages, I'm going to call conventional damages for counterfactual loss, and user damages on the other hand. That was what she was concerned about. And then if we look at 41, paragraph 41 at page 165, I have proceeded on the basis that route and park damages are assessed on a basis that affords compensation to the claimant. Now, if we go on to page 171 of the judgment, paragraph 58, you can see at the bottom of that page, so she's been considering Blake, and then she says, this is not a line of thought that I can pursue if, as the defendants submit, this court has held that such an award can only be made in the case of a proprietary tort in a manner binding on this court on this appeal. I therefore need to consider the decision in WAS. And what she is looking at there are damages. She has been comparing damage but for damages on the one hand with other damages, including user damages on the other hand. And she's approaching WAS on the basis that it's precluding her, is it precluding her from awarding damages other than purely compensatory damages, so damages for counterfactual loss. And then let's go to paragraph 74 and 76 that you've looked at a number of times now. So before that, let's go to page 175, paragraph 71, under the heading WAS. You can see, so there's nothing nothing at all in this paragraph that indicates that that the learned Lady Justice had misunderstood Was in any way. And you can see there in the middle of the paragraph, the judge found as a fact that the council suffered no loss as a result of the holding. That's pecuniary counterfactual loss. However, he made an award of user damages by reference to the licence fee. So again, the distinction that's being drawn is that between pecuniary counterfactual loss on the one hand and other forms of relief, of remedy on the other hand, including user damages. So that's the critical distinction. And then if we go to paragraph 74, we see the ratio of the judgment of Lord Justice Norse is therefore that the user principle ought not to be applied to the infringement of a right to hold a market where no loss had been suffered. Again, you have to insert pecuniary counterfactual loss, that's what she's talking about. And then at 76, Lord Justice Norse regarded the underlying rule, and the underlying rule being about the availability of purely compensatory, counterfactual pecuniary loss, but the exceptions to it are those that he specifies. And then we see that from over the page at B. Nonetheless, it was an essential part of Lord Justice Norse's reasoning that damages by reference to the benefit obtained by the defendant could only be awarded in those limited situations, and it would, in my judgment, have to be shown that his circumscription of the cases where damages were not assessed on a purely compensatory basis could not stand with Blake's case. And then at the bottom of that paragraph, it cannot be said that a case that holds that damages assessed on a purely compensatory basis are the only damages available for the torts other than proprietary torts is necessarily overruled. So we say that on a fair reading of this judgment, first of all, it's clear that Lady Justice Arden understood what user damages are. Secondly, she indeed recognised that in some senses they may be viewed as compensatory. But thirdly and critically, the distinction she was drawing, the reason why Was was important, even though Devonish itself was not a claim for user damages, the reason why Was was important is that the distinction she was drawing was between purely compensatory damages on the one hand, so damages for pecuniary loss in a but-for sense, and other forms of relief, including user damages on the other.
But the difficulty I have with her analysis here is that Lord Justice Norse undoubtedly declined to extend the exceptions to the conventional rule to the example there, and part of his reasoning was concerning proprietary torts. But he certainly did not say that you cannot extend it to a non-proprietary tort. And he made it absolutely plain that the law was evolving and that the cases had to be looked at one at a time.
Well,
and, indeed, and that's also what Lord Justice Nichols said.
Well,
so I find it hard to see how one can say that Lady Justice Arden was otherwise than in error in regarding there a binding ratio here that only that you could not in any circumstances have user damages for a non-proprietary tort. They just didn't say that.
My Lord, to that, we say that our primary submission is that you are bound by the terms of Devonish. That's what Lady Justice Arden...
Not if she's in obvious error.
Not if she's in obvious error. We say she's not in obvious error for these two reasons. First of all, because when one goes back to Was, true it is, I accept the point, that what was at issue there in both of the main judgments was whether or not a further exception should be made. But they decided not to make a further exception. So where the judgment stands...
That's like a logical fallacy to me, to say because they decide you can't make this further exception, that you can't make any further exception.
Well, my Lord, they decided not to make a further exception, that there was no basis...
In that one specific instance, as they made absolutely plain.
And, my Lord, my second point is that when one looks at one step, it is impossible, we respectfully submit, to say that Lady Justice Arden is in error, because you look at what Lord Reid says about the availability of user damages in tort. He says exactly the same thing. He says they're available for trespass, detinue and conversion, and for patent infringement.
Well, if she was in error in 2009, she can't have ceased to be in error because of what subsequently happened in one step, can she?
Well, my lord, my response to that would be to say that that is taking without meaning to be disrespectful, pernickety an approach, because you have what's said in one.
Don't worry, there are lots of criticisms of me in this area.
So you have the decision in WAS, which goes through the categories of case in which user damages are held to be available, and they are effectively the proprietary torts. And both Lord Justices that gave the substantive judgments both found that the cause of action in that case was not one in which a further exception should be made. It's true that they did not consider themselves
They didn't express a general principle, did they?
They didn't consider themselves precluded from formulating another exception. They didn't consider themselves precluded, but the way in which they proceeded was to look at the rationale for user damages, look at the categories of case in which it had been awarded, and decide whether this case was one which effectively...
But we have to be careful about the doctrine of precedent, don't we? And we're well used to the concept of distinguishing decisions. And it seems to me that to say, as Lady Justice Arden did, that looking at what Lord Justice North said, and even taking him on his own, and assuming that she's right in saying that you can have two ratios from one case, that was the right conclusion to reach.
Well, my lord, the reason I use the word pernickety is because when one is standing back, in order to get to the point where you say Lady Justice Arden was clearly in error, such that we're not bound, which would be, in our respectful submission, a significant step, given we say the
well, all we need to say at the moment is that we're arguably not bound.
But this is, as my learned friend has said, a question of law on which you are perfectly able to determine now, having heard full argument. And we say that on that point, it does make sense to grapple with the point now. So it's difficult to see how the picture's going to change depending on trial, because this is really a pure law of a pure point.
Do you say that she was right in the last sentence of paragraph 71 to say that you can be bound by two ratios in one case?
Yes, so long as there's no inconsistency between the ratios. If there were inconsistency, then... Because technically, she's correct that Lord Justice Mann agreed with both. Now, if you're in a situation equivalent to the Gold case, where there's just an unavoidable inconsistency between the ratios, then that's tricky. But here there is no inconsistency. And those points I made in opening, because both judges were addressing the same question. Both judges looked at the case law hitherto and identified the categories of case in which user damages were available. And both then ultimately decided that the cause of action in play in this case did not fit within that schema.
Mm. I mean, just going back to your categorisation of an approach as pernickety, and I understand what you say, but isn't that what the doctrine of precedent and whether we're bound by a decision? It is quite a precise question, and it's only if it's a technical issue, and it's only if looking at it very closely and, if you like, in a pernickety sense, that you are technically bound, that you are bound.
Well, my lord, there's pernickety and pernickety.
We don't do it on a broad brush basis, do we?
So I'm not saying a broad brush basis. One does have to be precise, that's correct. But one has to be precise. We say you look at this with precision. She is saying that that the only cases in which non-counterfactual pecuniary damages are available are the proprietary torts, and so that she's found that clearly.
Yes.
And so the question then is there an obvious error? And we say, no, you have to work quite hard to identify any error at all, particularly in circumstances where the Supreme Court, in one step, what it said is completely consistent. It considered WAS.
Well, no, the only question we're involved with here, leave aside one step and the the overall issue, because you're not, at this point, you're not relying on one step. You're saying that this judgment is binding.
I am.
And so the only question at this point is, when Lady Justice Arden said that she was bound, that that court was bound, was that correct?
Well, my Lord,
Or was it obviously an error?
Well, my Lord, we say not obviously an error, because in order to try and eke out an error, what you're having to say is that that because Lord Justice Nichols and Lord Justice Norse in Was contemplated that in theory there could be an exception to these categories. So don't forget that Lord Justice Norse did set out the categories which were themselves exceptions to the general rule about availability of non-compensatory damages. So what you're having to eke out is to say, because they contemplated that there might in theory be an exception, even though they didn't find that there was one in that case.
Well, no. Well,
this is an error.
They're talking about this being well, we've looked at it. They're looking at it as being a developing area of law, and they plainly anticipate that it will continue to develop. In fact, Lord Justice Nichols says that in terms and declines to make a firmer finding other than specifically in relation to a market. And so that they are not making a definitive statement about what the exceptions are. Quite the opposite. They're making it very plain they're not.
Well, my Lord, the way that we read Lord Justice Norse is that he's identified the exceptions to the general principle. Then he considers whether there should be another exception. I accept that Lord Justice Nichols puts things slightly differently
Well,
on
there
this.
should be this particular exception.
This particular exception, but then what he says is no, because that would revolutionise the law of tort and enable these damages to be sought to be recovered all over, which is not how the law of tort operates.
Yeah.
So,
Can I just ask you, just in relation to this, what Lord Justice Nichols actually says on page 1418, at C, he says that the common law is evolving, not attracted to, simply said, to novelty. And then in the next paragraph, well, he then says, at surface value, he's quite attracted to the argument about extending the right of user damages. But then at F, he says that that would not be consistent with the basic principles applicable to that cause of action. And he then goes into precisely what the market right covers.
He does.
Which is a very limited market right. It's almost Section 18 turned inside out. And for that reason, halfway through, in such an event, there's no place for award of damages. Now, if you applied his analogy to Section 18, you might say he'd come to the opposite result. But I think for our purposes, he was contemplating extending user damages. He asked himself what the cause of action, the statutory cause of action, led to. What was the nature of the right being conferred? It was actually quite limited. And it was on that basis that he concluded that you shouldn't extend user damages. And of course, Lord Justice Mann agreed with him.
yes. So I accept. So first of all, I don't accept that this. I'm going to pray and aid Lord Justice Nichols when it comes to the second part of my submission, which is that the cause of action is key. But for these purposes,
We get that. Yeah.
for these purposes, I accept that Lord Justice Nichols' formulation is narrower than that of Lord Justice Norse. Yeah. But Lord Justice Norse, but it's not inconsistent, and so it wasn't wrong of Lady Justice Arden in this section of her judgment in Devonish to take the ratio of Lord Justice Norse's judgment. It's not inconsistent with Lord Justice Nichols. And in fact, Lord Justice Mann, I think, would have been extremely surprised to learn that they were inconsistent, given that he agreed with both. They're not inconsistent. They run together.
If they're not inconsistent, are we not entitled to just apply the logic of Nichols as it's set out on page 1418?
My Lord, no, because the
you
doctrine of precedent isn't a sort of pick and mix, choose whichever bit you want. I mean, that this is Lord Justice Norse's judgment is a majority judgment. It was applied by Lady Justice Arden. She extracted from it a principle which is clear on its face. None of my learned friends' submissions about restitution and the labels hold good. We say
It wasn't
those
a majority judgment. Sorry, did you say it was a majority?
Yeah.
It's not, it's unanimous judgment, that's the problem. In
Sorry?
Wass.
No, Devonish is majority.
Devonish.
And Devonish, oh sorry, Devonish, I beg your pardon.
She was entitled to so the two questions are, was she obviously in error? And we say this doesn't come close to the case law referred to by my learned friend in his skeleton of obvious errors. And secondly, we say it's not an error at all, in fact. You have my submissions on that. And then secondly, is there any necessary inconsistency between the judgments of Lord Justice Norse and Lord Justice Nichols? And we say no. And if one's asking the question, does Lady Justice Arden find that damages other than compensatory but for damages are available in competition claims? She says, no, they're not, because of WAS, which was a user damages claim.
We have to be slightly careful about that concept of are they available in competition claims. The only claim in front of her was a specific claim in relation to cartel. The concern was to avoid the problem with parcel. There was no issue, the issue in that case did not concern in any way the argument in this case, which is one that abuse involved interference with a right to control an asset. So that was simply not on the radar, was it?
That's a fair point, my lord, but and I put it slightly too narrowly. What she was saying was that damages other than counterfactual damages for pecuniary loss are not available in tort outside the pecuniary torts. That's what she found. That's what we rely on. And of course, competition law is not proprietary tort. It's not a proprietary tort. So that's what she found clearly.
Even then, it might be said that the problem that arises in this case simply wasn't on the radar, and that's how the common law works.
Well, that then bleeds into my second submission, which is that my learned friend is wrong. So even leaving aside Devonish. But it is, I don't entirely accept, I'm going to come back to my Lord's temporal point, which is that you can't consider one step when you're looking at whether Lady Justice Arden was right. And that's why I think perhaps...
Well, it's not whether she's right, it's whether it's binding.
Yeah, but in order not to be binding, she has to be clearly wrong. And it would be very surprising...
Well, clearly wrong when, though?
Well, I'm not going to accept this point of the temporal point, because when one is... You're right that as a matter of strict logic, one is looking at it at the time, so I accept that. But there has to be a sort of realistic analysis of whether or not the error is sufficiently serious, and that can take into account later.
A decision that's not binding can't become binding many years later.
My lord,
And that would be a very odd. That would mean that lots of decisions in the meantime would be retrospectively somehow rendered.
My lord, I accept that point. Let me put my submission in this way then. You are faced with a question in as against the clear, we say, ratio of Devonish. You are faced with the question, should we disapply it? Should we say it doesn't bind us on the basis of an obvious error? And we say, you're right, you need to look at whether it's an obvious error at the time. That's perfectly correct. We know what the ambit of the debate is. It's whether Lord Justice Norse, in contemplating there being a further exception, whether that means that the finding of Lady Justice Arden was obviously an error. We say no, because he didn't pin his judgment on, in quite the same way. He didn't approach his judgment in quite the same way as Lord Justice Nichols. In fact, even though he contemplated that there might be an incremental change or a further exception, he found that there was not, and he said that to find to find the opposite would revolutionise the law of tort. So we say that when reading his judgment, there's certainly no obvious error by Lady Justice Arden. And then what one can do is step back and say, well, actually, the law hasn't changed, and where we've got now on the highest authority is in exactly the same position. So it's a sense check. But I accept that analytically you need to look at it at the time, but it's a sense check. So is this the kind of error that's so obvious that it should lead us to disapply this judgment? So that's those are my submissions on Devonish. I want to turn now to the second part of our submission, so the legal flaw in my learned friend's submissions that arises even if even leaving aside Devonish. Now, my learned friend says that the law requires the court to focus on the facts pleaded to ascertain whether there's been a wrongful interference with property. And he says, if so, user damages are available or might arguably be available. That's his position. And my learned friend said repeatedly that the source of the right that's being invoked does not matter. And we say that that submission is inconsistent with the authorities, namely One Step and Lloyd Google. And can I just take you back briefly to those authorities, and I will finish by one. So if we turn up One Step first, so it's Authorities 1, tab 11, page 302. Now, paragraph 95.1, which you've looked at before, explains the availability of user damages in tort by reference to these causes of action, detinue, conversion or trespass. What Lord Reid doesn't say, this is the first point, is they are available in tort wherever the facts of the case allege an interference with property, or wherever on the facts an interference with property is established. That's not his approach. And you see that that's not his approach by analogy in contract either. So going back to paragraph 92 and 93, he explains at paragraph 93 that it might be said that there's a sense in which any contractual right can be described as an asset or indeed property, but that's not the touchstone for the availability of user damages. The touchstone is whether or not the breach can result in an identifiable loss equivalent to the economic value of the right considered as an asset, even in the absence of pecuniary losses. And we see from paragraph 92 that what he's talking about are breaches of contract resulting in the loss of a valuable asset created or protected by the right which was infringed. Created or protected by the right which was infringed. Now, my Lord Justice Phillips picked up on the words in paragraph 92, has in substance been deprived of a valuable asset, but they cannot, we respectfully submit, that word in substance, those words can't, we respectfully submit, be read, when read in context, cannot bear the weight my learned friend seeks to place on them. And we can see this from paragraph 93, where the distinction is made between pecuniary losses and losses only in some circumstances, which can be compensated by means of user damages. Now, my learned friend's submission that one focuses on the substance of the facts rather than the cause of action was, we say, rejected starkly by the Supreme Court in Lloyd and Google. And you'll recall that in that case, the claimant's argument proceeded in two stages. So they argued on the basis of Gulati that the facts pleaded in Lloyd and Google, namely that people's data had been taken by Google, used by Google without their knowledge. They argued on the basis of Gulati that those facts would give rise to a claim for user damages in the tort of misuse of private information, and that accordingly user damages were available for breach of the Data Protection Act. In other words, they relied on the factual allegations, the fact of interference with property, to argue that user damages were available for breach of the Data Protection Act. And Lord Legate's response, can we just turn up Lloyd Google? So Authorities 1, tab 13, if we take it from page 393, that before I get to the particular parts of the judgment, Lord Justice Legate's response was, yes, user damages, that the tort of misuse of private information would naturally lend itself to an award of user damages, but user damages were not available on the very same facts for breach of the Data Protection Act. And so the cause of action was determinative. It's not right to say, well, if in substance there's been an interference with property rights.
But that was because of the interpretation of the statute.
Yes, it does. But It does. So it means that you've got to interpret the Competition Act to ask yourselves.
We haven't looked at the Competition Act.
We only haven't looked at it because it's so familiar to your lordships. It says nothing about what damages are available. And the key question is whether, properly construed, the Competition Act confers a right to user damages. And we say no. I'm going to come on to that. But the point that I'm on at the moment is that what Lloyd Google demolishes is my learned friend's argument that it's all about the facts. As long as you can establish an interference with property on the facts, that's it, that's the touchstone. It's not right. You've got to look at the statute. And if we look at Lloyd Google, if we take it from page 393, I took you to the common source argument, which I've now just summarised again for you. But looking at para 124, Lord Leggett says this. He says it doesn't follow from the fact that two legal regimes aim at a general level to provide protection for the same fundamental value, that they must do so in the same way or to the same extent or by affording identical remedies. Now, we are a fortiori this in this case because, of course, the Data Protection Act does look to be protecting data in the same way that the tort of misuse of private information does. But competition law is much more removed from that. It's not protecting the same right. Competition law is imposing a regulatory duty. But even where the two causes of action
What is the regulatory duty then?
not to distort competition in the market through anti-competitive behaviour.
Not necessarily under Section 18A. It is to protect consumers as well from unfair terms.
Only if that's exploitative of a dominant position.
But on the hypothesis we're talking about today, there is.
My lord, can I come back to that? Because I am going to grapple with that. But can I finish? Would you mind if I finish with Lloyd Google first? But I will grapple with your point. It's important. So then if we look at paragraph 130, page 395, you see a discussion of material differences between the regimes. I don't need to go into detail, but I just want to show you the structure of Lord Leggett's reasoning. And then if we go on to page 398, and you've now looked at paragraph 141 a number of times, a claim in tort for misuse of private information based on the factual allegations made in this case would naturally lend itself to an award of user damages. But, and this is critical, 143, the point does not arise in the present case because the claimant is not claiming damages for misuse of private information. The only claim advanced is under the DPA. And under the DPA, user damages are not available. And so, just pausing here, of course, you do have to, I accept, interpret the Competition Act, but the point I'm on at the moment is addressing my learned friend's point that it doesn't matter what the source of the right is or what the cause of action is. That's plainly wrong. So, even if it's right, and we accept this for these purposes, that the touchstone for the availability of user damages is that property has been expropriated or invaded or interfered with, however you want to put that, that itself does not give rise to an award. What's critical is the cause of action, the source of the right. Now, the torts of trespass, conversion and debt in use seek specifically to guard against invasion or wrongful use of property. If a person makes good a claim in the tort of trespass, it follows that his property has been invaded without his agreement. So, in a sense, even though, and I take the point made by Lord Justice Phillips yesterday, one might say that the tort of trespass is not constitutive of a property right, it does nonetheless represent the means by which a property right is vindicated. And so, if the tort of trespass is committed, if that cause of action is made good, you have, by virtue of that fact, an invasion of a property right. You don't need any further analysis. The competition rules, by contrast, do not provide a means for protecting private property rights. The statute is not concerned with the protection of private property rights. Competition law is different. It is concerned with preventing distortions of competition in the market. Now, coming on now to the point put to me by Lord Justice Green, it's true, and I don't shy away from this at all, that anti-competitive behaviour may be behaviour which exploits consumers. That may be a form of exploitative abuse. So imposing terms which exploit consumers unfairly may be a form of abuse. But that doesn't establishing that does not establish a breach of a property right. Let me just explain that a little bit further. Competition law always, in our submission, requires a counterfactual analysis. A counterfactual analysis in this sense, that one is always, when one is asking, has there been a distortion of competition here? Has there been anti-competitive behaviour? One is always comparing what's happened in the real world, so the alleged anti-competitive conduct, with conduct that would have taken place under conditions of effective competition. And going back to a point put by my Lord Justice Green to my learned friend, that is true in the excessive pricing cases too, because in the excessive pricing cases, as the court knows very well, one is asking, is this price abusively high? And what you're doing is comparing the price with the price that would pertain if it weren't a dominant firm in conditions of effective competition. That is a counterfactual analysis. Now, one may not use that analysis precisely to quantify loss.
Well, it can be, I agree, but it's not always. You can have an abuse found simply by looking at cost plus, measuring it against the ASP and asking whether there's a justification for the difference. That's non-counterfactual. I accept there are counterfactual evidence might come into the equation.
My Lord, I want to draw a distinction because this is important. So a cost plus analysis may not be classically a counterfactual analysis, but you cannot establish, just at a very fundamental level, you cannot establish a breach of the competition rules, leave aside quantification, just abuse, without comparing what's happening in the world now with the world absent the abuse. So that's just quintessentially a thing that you have to do in all competition cases, because you're asking yourself, take unfair terms, you're asking yourself, well, if this firm didn't wield this market power, so competition law, as we know, is not a law of consumer protection. You've got to establish that a firm's abused its dominance in a way that is prohibited by the rules, and you do that by asking yourself, well, what in a situation where you don't have a dominant firm, would they have been able to exact these terms from consumers? That's what you're asking yourself. It's not a freestanding question of whether these terms are fair, because you may not like a particular term, but you're asking yourself, well, if this were a competitive market, would this dominant firm be able to charge this amount? Would it be able to exact these terms out of consumers? That's always the question in a competition case. And our point is that if a claimant succeeds on a competition case, that does not establish that his or her property rights have been invaded. Let me explain why. Because take this case. So take this case where there's an allegation of unfair price. We say either there was an unfair price by comparison with the counterfactual, or there was not. Now, there's no room for user damages, because user damages, it's anathema to user damages to have any counterfactual analysis. The whole point about user damages is that they are available even if, in the counterfactual, somebody would not have charged a fee for use of their property. Take transparency. Let's say that an abuse is proved in this case. Obviously, Meta denies this, but that's for trial. Let's say an abuse is proved, which comprises that Meta's terms were insufficiently transparent, but no unfair price. Why should user damages be available then? Because consumers may still have agreed to let Meta use their data, even if terms had been more transparent. So you have to engage in a counterfactual analysis. And for user damages, the point is you don't. So why, as a matter of competition law, if you've established an abuse that terms are unfair, but even if unttransparent, but even if they've been transparent, users still would have parted with their data. Why should that give rise to any claim for user damages? It shouldn't. You've solved the competition problem. There is no pecuniary loss arising from that. You can, if necessary, seek an injunction, not pleaded in this case, in relation to future conduct. But there's no basis in a competition case for user damages to step in those circumstances to provide compensation in circumstances where, regardless of the abuse, consumers would have done the same thing anyway. Again, there is in this case an agreement between Meta and users, and this claim is about the terms of the bargain. If the terms are unfair, might be an abuse, but you can't conclude from the establishment of the cause of action. So unlike the proprietary torts, you can't conclude from the finding of an abuse that property rights have been invaded, which is the touchstone for user damages. Not even on these facts, which are said by my learned friend to be the most adjacent to proprietary torts facts. You can't conclude that because consumers...
That's dependent upon what you mean by invaded or violated. So on the worst case hypothesis for Meta, the CAT finds that the property was extracted unfairly and abusively, notwithstanding that it's contractual, and or that they were not paid for, either at all or adequately, depending upon how you define the category of information. Are those not an invasion of property rights? Not in English traditional, Megarian Wade sense, but from the purpose of the statute, is that not an invasion of property?
No, because the statute is concerned with preventing anti-competitive behaviour, and then what you have as a concomitant right as a claimant, as a person that's been at the wrong end of anti-competitive behaviour, is a right to claim damages for counterfactual loss. We see that in the damages directive. That's the basis on which all the case laws proceeded. The key distinction between competition law and the proprietary torts is that the proprietary torts are the means of vindicating property rights, same as misuse of private information. That's the cause of action which gives teeth to the property right. Competition law doesn't do that because it's looking at something else completely, and you can have an abuse established which does not establish, nonetheless, that you'd have to engage in a further counterfactual analysis to work out whether, in fact, property rights have been invaded or interfered with wrongfully. The fact that clauses might not be transparent enough, and that might be termed an abuse, doesn't follow from that inexorably in the same way that it does from the law of trespass or conversion, that property rights have been invaded. Because what if most of these consumers would have said, all right, well, yes, okay, well, it's nice that they're a bit more transparent now, but had they been more transparent, we would have done the same thing in any event. There's no invasion of property rights in those circumstances.
Could it therefore turn on the precise way in which the CAT finds there to be an abuse?
My lord, no, because it comes down to, and I know that you're attracted to this, but even now, my learned friend has not provided you with any facts that might bear on this at trial. Even now, and it can't, because it is a pure question of law, and we say that in the same way as Lord Leggett found, again, to drill down and expose the point of law between us. My learned friend says doesn't matter about the source of the rights, it's all about the substance. We say, well, that's plainly wrong. Look at Lloyd Google. You do need to consider what competition law is there to do. And we say it's in a completely different, its purpose is not to protect private property rights. And it would be dangerous for this court to find that user damages were available for breach of competition law, because that's simply not what the tort is getting at. And in the same way, as I've said, I'm now repeating myself, but the proprietary torts and misuse of private information are the means for vindicating the property rights. So once you've got a breach, you know that there's been an invasion of property rights. You don't have to do a counterfactual analysis. Completely different for competition law. And the trap that they're falling in is to say, well, the facts are similar. Facts are similar to these other torts. Therefore, we should have the same damages. And that's the error.
In one step, the Supreme Court proceeded, looked at the question of the availability of user damages as a matter of principle. But as I read Lord Sumption, paragraph 124, he actually was, it's implicit, but I think he's saying that it would have been better if the court had actually known what the outcome of an assessment of damages was. He says that because...
Where are you looking, my lord?
Paragraph 124 on
Yeah.
page 315.
Yeah.
He says because the trial judge had not determined the quantum of damages, this makes it necessary to proceed at the same level of abstraction in determining the present appeal. Which I think I read as saying it would have been better if we'd known what we were actually dealing with.
Well, my lord, can I just make a point about Lord Sumption's judgment more generally, because it does actually assist us. The reason I haven't majored on it at all, or in fact mentioned it, is because Lord Carnworth prefers Lord Reed's analysis, and so it doesn't form the sort of majority view. But can I just show you what he says, because it places the point you've just put to me in context. So I've intruded past 1 o'clock, but I'll do this quite quickly. So if you go to page 306, para 109, see, the more difficult question is in what circumstances damages may be assessed on this basis. That's the user damages point. And then he says over the page, the case law can be conveniently categorised under 3 heads. Cases in which damages are not limited to pecuniary loss because the claimant has an interest in the observance of his rights, which extends beyond financial reparation. Just emphasise that, I'm going to come back to it. Then we've got cases in which the claimant would be entitled to the specific enforcement of his right, and the notional release fee is the price of non-enforcement. And then thirdly, cases in which the claimant has suffered conventional pecuniary loss, and effectively the notional release fee is a tool to calculate the quantum of that loss. So it's his category 1 that we're interested in here. So his category 1 is what's going on here. They're saying this is a case in which damages are not limited to pecuniary loss because the claimant has an interest in the observance of his rights, which extends beyond financial reparation. And when you look at what Lord Sumption says about category 1, he refers back to WAS, so another endorsement of WAS. And then at page 308, beside letter B, the exceptions in the case of trespass to or appropriation of property are justified by the nature of the right which the wrongdoer has infringed. Property rights confer an exclusive dominion over the asset in question. The law treats that exclusivity as having a pecuniary value, independent of any pecuniary detriment he may have suffered by that breach of duty. So we say that this is of assistance to us because competition law simply does not protect any exclusive dominion over property. He's saying trespass and appropriation of property, those are exceptions because the right confers an exclusive dominion. Now, in this case, far from any exclusive dominion, users have contracted with Meta to allow Meta to use their data, and competition law does not confer any right to exclusive dominion. So we say that looking at his judgment and applying his reasoning to our case, it's helpful. And the point that you put to me, my lord, if you're in category 3, so if you're in circumstances where you're in a different category of case, so you're trying to use a notional bargain in order to calculate loss, then it may be that you need a trial to see what the damages are. But we're not. We're in the pure point of law, which is really illuminated by what Lord Sumption says at paragraph 110.
Nick.
We raised with the respondents the question of injunctive relief. So if you're right, and indeed I think in paragraph 95 Lord Reed refers to Lord Cairns Act and the possibility of an injunction. And I know it's not pleaded, but one can't preclude the possibility at the end of a trial in which there's a long debate about user damages. The court says, since WAS says we could impose an injunction in lieu of damages, and that takes us to Lord Cairns Act, what should we do in relation to that?
Well,
what would your response be? I know you'll say it's not pleaded, but it could emerge.
So my response to that is that you're only entitled to, it's the same as my response on the substance of the case, you're only entitled to an injunction for breach of the statutory right. So an injunction to prevent a breach of competition law. So you can't have some other injunction which doesn't correspond to the statutory right that's being accorded. So an injunction to prevent a breach of competition law is a different beast for all the reasons I've been giving to an injunction requiring, how would it be, requiring Meta not to use...
Well, it would frame its injunction by reference to the abuse that it found.
Well, that's our point, my lord. So the point is that the abuse is an abuse which comprises acting anti-competitively and distorting the market as compared to the counterfactual. That the provisions do not protect property right, and so the species of injunction you get, it is an injunction. You can only get an injunction which is to prevent
continuation of the abuse.
Yes, exactly.
But if the abuse, well, it depends how they frame the abuse.
Exactly, and
if
that
they
comes
frame
back.
it in the way the CR does, you could frame an injunction which would be highly damaging, and I suspect there'd be a long debate about whether that was a sensible thing to do vis-a-vis an injunction, in which case the court may say, what about damages in lieu?
What, damages in lieu of what? Damages.
An injunction.
But the
under Lord
injunction.
Keynes's Act.
The reason I say it comes back to the same substantive point is that the injunction would be an injunction limited to requiring Meta not to abuse its dominant position. And what you don't get from that is any notion, and that comes back to my same point. So if you say to Meta, please don't, or we injunct you from abusing your dominant position, doesn't follow from that anybody that hasn't suffered pecuniary loss has suffered a loss in a competition law sense for the reasons I gave earlier. So it doesn't work. It doesn't get round the fundamental problem.
I understand that, but the problem is that, and it's very odd, but if user damages are not applicable and you get into Lord Keynes's Act and an injunction is considered to be inappropriate and the tribunal then goes to damage review, it then can resort to user damages.
No, my lord, we say no, you can't. So you can only resort to user damages. You can only resort to user damages if that fits with the type of injunction you're seeking. So you can't say in every case. So let's say you've got a case of negligence. You can't say, oh well, I'm going to get an injunction and I can have user damages in lieu. That doesn't work. So that's not right. So it comes back to the same point of principle, which is that you can get an injunction to prevent breaches of competition law and to prevent abuses. And the damages in lieu, if there are damages in lieu, will be damages in lieu of preventing a breach of competition law, which for all the reasons I've given, breach of competition law does not equate to the sort of loss, does not of itself give rise to the sort of loss that is represented by an award of user damages. And that comes back to the same substantive point. So it's not some sort of loophole which they could use to get around the fundamental conceptual problem they've got with their case for user damages.
Thank you very much indeed. Thank you all. This is like the most difficult of exam questions. We will reserve judgment. I can't promise we'll get it out before the end of the month, before the end of term, because time is short. But we will do our best. And when it comes out, it will come out on the normal terms for editorial comments only. Everybody understands the limitations in relation to confidentiality. And we will, insofar as it is appropriate, ask the parties to just agree an order, and we will then take it from there. Thank you all very much indeed.